May I have your lordship's millet leave millet? Is that Vizag matter millet? It's appearing as item number 57 in your lordship's non-commercial list millet. Will it commence your lordship millet to fix the matter on Wednesday, which is a non-commercial day millet? I believe this won't be taken up because there are orders millet. I have been arguing this matter. I will take one more day and then Mr. P.K. Ghosh will.
Let us see. We are in. There's a lot of matters to be attended to.
I understand millet.
আজকে তো হবে না, হিয়ারিং হয়েছে তো এগুলো নেমে গেল কেন এত নিচে? প্রশ্ন সেটা না, কমার্শিয়াল আর কমার্শিয়াল লিস্ট তো আলাদা। তাহলে কোনোদিন ওটা উপরে উঠবে, বুধবার দিনই উঠবে, তো উঠলে তাহলে বলে দাও সেটা।
Wednesday millet. Can a time be fixed? Because millet, on the last occasion, lordship will kindly take 16th July's order millet.
Please. It creates a lot of difficulty for us, Mr. Ghosh.
Fair enough millet. We'll come back on.
Millet. Appellate side, may I seek your lordships kindly to mention this matter? I'm mentioning out of abundant caution. Your lordship, this is some impending urgency. It's supposed to be listed on the 5th of next month, your lordship, 5th of August.
Yes.
Can I just hand over this slip because there's some impending urgency. The Alipur commercial appeal from the Alipur commercial.
No, if it is supposed to be listed, Mr. Chakraborty, it will be listed.
It will be listed just if it can be.
Near now.
So is leading me in this matter. He's on some difficulty subsequent to that, Mr. Join.
Very good. So, next.
One appellate. May I leave to?
Yes. First physical.
Yesterday's list, item number 17 and 18. 17 is my matter.
That matter
18
appeared.
Yes.
18 is his matter.
Probably my mistake. My learned friend says that is 17.
17 is my matter.
Order should be on item 18.
That
but
order,
I got surprised because the file was with your lordship also. That award matter, my lord.
Sorry, what can be done? We have signed it. It's on the server. What can be done?
It has been passed in item number, wrong item.
It has been, order has been passed in item number 17. It should have been in item number 18.
হ্যাঁ, কিন্তু আমরা সই করিনি।
No.
আরে বাবা, সই তো হয়ে গেছে। কি আশ্চর্য।
Let it come as to be mentioned.
Come as to be mentioned.
Come as to be mentioned. But I was also surprised because your lordship was looking at the file also.
Both the items shall be mentioned, listed as to be mentioned. জেনে নাও কোনগুলো?
কালকের 17 আর 18 আমি
নাম্বারটা
দিয়ে দিচ্ছি।
Which list, commercial, non-commercial, point out?
নাম্বারটা লিখে দিই।
হ্যাঁ দিয়ে দিচ্ছি।
Yes, give the numbers.
To be mentioned on Monday.
Tomorrow.
Yeah. কাল তো কোথা? Yeah, tomorrow.
My lord, I mentioned this matter yesterday, my lord.
Monday.
Why? Tomorrow is a working day. Monday.
আমরা সব লিখে দিয়ে দিচ্ছি 17 18 দুটোই দিয়ে দিচ্ছি টু বি মেনশন মানডে
Yes.
My lord, the matter was appeared before the Justice, Honorable Justice Subhashachi Bhattacharya, my lord. The order was passed that the trial court record shall be brought before the court upon the cost of the expenses of the appellant. Now, my lord, there is one dispute cropped up by the department concerned informed us that the...
Sir, his lordship will be available from Monday. Please go and mention before his lordship.
I mentioned this matter yesterday for extension of interim order, my lord.
It has not appeared. Hello?
This is from the determination of my lord, Justice Procedural order.
When is it expiring?
My lord, yesterday is
expired. Tomorrow will you come to court?
My lord.
কালকে যেন লিস্টে থাকে। ফাইল আসুক না আসুক, আর না এলে আমি চাইবো। হ্যাঁ, না এলে আমি করবো, শোকজ করবো। কেন আসছে না বলে দিও, সত্যি করবো। Yes.
My lord, may I leave to mention now on
Yes.
my lord, regard to item number 4 of the appellate side matter, my lord, it is so urgent, my lord. Can it be taken up tomorrow? My lord, today, my lord, perhaps your lordship's urgency matter may not be exhausted.
Tomorrow, appellate
So,
side list will be taken up first. So be there.
My
It will
lord.
be done. Issue.
I'm grateful. I'm grateful, lordship. I'm grateful.
Kishi's item number 1. Oh,
But we have served it yesterday.
And this is in the evening or I am appearing here for the defendant respondent.
yes. What was the matter?
My lord, this is an agreement for sale. My lord, it is in
Very well. You still don't have full instructions, you are saying. So what do you want? Tell us.
My lord, against the refusal of the identity order, my learned senior friend filed this appeal.
Yes.
My lord, my instruction, my lord, his specific case is that, my lord, on terms and condition of 2 crores 38 lakhs, my lord, the property will be transferred to him. My lord, on instruction I am submitting, and out of that, my lord, he paid 8 lakhs to my client. My specific instruction, my client is ready and willing to execute all of the sale deed in their favor. My lord, kindly assure that amount, kindly fix the date, and my lord, my client will execute.
So the status quo be maintained.
lordship.
My lord,
And
that-
this is settle the matter, Mr. Banerjee.
But we are ready, my lord.
My lord,
We are
I-
ready.
They are saying they are also ready.
My lord, status quo in respect of the property, my
my
lord.
lord, kindly fix the time frame. Otherwise, my lord, they are not paying. My lord, kindly fix.
कल क्यों थी status quo?
My lord, kindly fix the time frame, my lord.
Restraining the defendant.
But what I understand,
Accepting to. Yes.
My lord, I need to, my lord, sell this property by virtue of this, my lord. I am not able to. My lord, my
Yes.
client-
Show the color of money, Mr. Banerjee.
absolutely, my lord, we are ready. But we are told that there is a mortgage, my lord. My lord,
That is your problem.
no. It is their problem, my lord. They have,
Knowing that you entered into an agreement.
my lord, it was an understanding between us that they would clear everything. My lord, we are ready to pay.
Two
My lord, we are ready to
necessary.
pay.
My lord, two permission is necessary.
But we are
from,
ready
my lord,
to
the government authority.
We'll keep it next Friday. Do whatever is necessary in the meantime. Sit across the table. Sort it out.
My lord, in the meantime, let them maintain the status
Issue.
quo in respect of the.
Otherwise, my lord, this, my lord,
But we will do it.
that is-
But no problem, my lord.
You have filed a suit for specific performance.
Lordship.
The appellant has filed a suit for specific performance of an agreement for sale of a property, against the defendant before the court of the civil judge, bracket senior division,
Okay, bole.
second court, Barashat. Stop.
Okay, bole.
In the suit, the plaintiff applied for interim order to protect the property. Stop. The learned trial court refused to pass any interim relief, refused to grant any interim relief, Stop. Hence, the plaintiff has come up, paragraph, appearing for the defendant, learned advocate says that says that he has specific instruction that the defendants are ready and willing to convey the property to and in favor of the plaintiff upon payment of the entire agreed consideration money, which is rupees 2.38 crore. Stop.
out of, my lord, 8 lakh.
Only rupees 8 lakh has been paid till now. Stop. Paragraph. We therefore see that this matter can be settled between the parties. Stop. List this matter, Deki.
This is service, my lord.
List this matter once again next Friday, date diye dao. Paragraph. Friday ko tarikh?
8 तारीख
8th. Till August 12, 2025 or until further order, comma, whichever is earlier, comma, just status quo. Let status quo be maintained in respect of the property in question. Settle, go and settle. Right.
That determination is the what that is
No, why regular? It will go before the regular court. What's the problem? We have recorded whatever you have said.
Malad,
Settle it.
but if it is made Parthat Millard, we would be very great.
No. Sorry. We can't make you grateful.
I'm grateful.
কার রয়ে গেল
Yes.
Mr. Chatterjee is leading me so long. He comes, Millard. Let me start, Millard.
If it survives that long. Yes.
What happened, Millard? This is Millard. I'm the Millard plaintiff who have filed the Millard suit for declaration that Millard I cannot be dispossessed without following the due process of law. Now, Millard, in such a Millard suit, Millard, I had filed an application, Millard, for an interim injunction. Millard, that has been rejected by the Millard impugned order. Millard, kindly see, Millard, there are two.
এটা আমাদের না
The impugned order.
You had moved ex parte.
Ex parte ad interim, first time, Millard.
Go back.
No, Millard, two things, Millard. Kindly see,
There's
Millard.
nothing wrong in the order. What
No,
is
Millard,
recorded?
Yes.
There's
So
no
only-
clarity that you are the owner.
No, Millard, completely wrong recording. May I show the plaint?
Go and tell the learned judge.
No, kindly see, Millard. Once, Millard.
No,
for
Mr.
this
Bhattacharya.
Once, Millard.
No.
See the plaint, Millard.
A lot of matters are waiting.
There
There's
Millard,
nothing
I will
in
not
this.
disturb your lordship, Millard. Once, Millard, two paragraphs of the plaint.
Yes.
Kindly see, Millard, page 15. Kindly see, Millard, paragraph, Millard, at page 16, Millard, para 2. Kindly see, your plaintiff states that the plaintiff is a partnership firm which is being run by its partner from the said property. The said firm took settlement of the bare land measuring about 3 bighas, 4 cutters.
What does that mean? What does that mean?
Millard, court, Millard, records, Millard, the learned trial.
What does that mean? You became the owner.
No, I'm not saying I am in possession of the suit property and I cannot be throughout without following the due process of law. Even if, Millard, I am a trespasser. Let us assume that I am a trespasser, although I'm not admitting it. One, therefore,
No, look at your prayer A
yes,
of the plaint.
plaint.
Page 22, running page 22.
Yes, Millard.
What is prayer A?
The declaration that the plaintiff is the plaintiff has become the absolute owner of the suit property, but not by way of adverse possession. That is
Go back.
paragraph 2 and 3.
What else you want to show us?
Yes, paragraph 2, Millard. The learned trial judge refuses my injunction order of ad interim prayer, Millard, twofold ground. I have not stated that I am not in continuous possession and when I was inducted. Now, Millard, paragraph 2, 7/6/1980, I specifically stated that I took settlement. Paragraph 3, Millard, kindly see. At page 17, it is pertinent to mention here that the plaintiff company settled possession and occupation of the suit from the date of inception till date uninterruptedly, continuously, and to the knowledge of the original owner. Well, these are the two grounds the specific pleading was taken.
Very well. Issue. This appeal is directed against an order dated July 21, 2025, passed by the learned civil judge, bracket senior division, bracket close, 4th court, Alipur, South 24 Parganas in title suit number 1089 of 2025. Filed by the appellant herein. Appellant herein. Stop. Paragraph. In the suit, the appellant claimed the following reliefs. Running page 34. A, B, C. Paragraph. The appellant oblique plaintiff applied for an order of injunction, interim order of injunction, by interlocutory order of injunction, to restrain the defendant in the suit from disturbing the plaintiff's peaceful enjoyment of the suit property, and to restrain the defendant from dispossessing the plaintiff without following due process of law. Stop. The application was moved ex parte before the learned trial court for ad interim relief. Stop. The learned trial judge, by the impugned order, has refused to grant ad interim ex parte ad interim relief and has posted the matter on November 28. On November 28, 2025, directing service in the meantime. Paragraph. We have gone through the order under appeal. Stop. The learned judge records that the plaintiff's case is inherently inconsistent. Stop. On one hand, the plaintiff says that it got possession of the property in question under a in terms of a settlement under the defendant. Stop. On the other hand, the plaintiff claims to have become the owner of the property by way of adverse possession. Stop. Hence, the learned judge thought it fit to hear the other side before passing any order. Paragraph. We see no such infirmity in the order under appeal as would persuade us to interfere. Stop. We have also gone through the plaint. Stop. However, we do not make any comment on the merits of the case since the matter is pending before the learned trial judge. Stop. Paragraph. We only prepone the date, the next date that has been fixed by the learned trial judge, as we feel that November 28, 2025, is a very long date. Stop. The learned trial court shall prepone the date to any day in the month of August, 2025, upon this order being communicated to the learned trial judge by the appellant. Paragraph. Or everything appeal, everything disposed of.
But only one thing, Millard, kindly direct me to Millard serve these appeal papers upon the Millard respondents so that they have knowledge of the suit, because 28th November we have not taken
We have preponed.
Yes, but they should have knowledge of the suit. My lord has said in August.
Huh?
My lord would direct me to serve the copy of this order and the application for injunction to the respondent so that they have knowledge of the suit.
Of the suit?
Of the suit in the trial court.
Trial court has already directed
Yes, sir.
service. So you serve. Disposed of. Why should we? Yes. কি হচ্ছে এই মামলায় কেউ কিছু বলছেন? Yes.
Millard, status quo, Millard, kindly see, Millard, if I am dispossessed, Millard, what remains?
No,
I
Mr.
appreciate, Millard.
No, sorry.
Millard, may I Lord, my video isn't working. May I most humbly, Lord,
Oh, Mr. Chatterjee, my lord, is looking.
Sorry, it has been disposed of, Mr. Chatterjee. No, call the next matter.
very well, my Lord. Grateful, Lord.
Commercial bank, legal side.
Please.
Application item number.
My lord, may it please your lordship. My lord, this is my appeal against an order disposing of interlocutory application. If your lordship kindly takes the memorandum of appeal.
Why are you on virtual mode, Mr. Bhattacharya?
My lord, I am not in town.
We don't find it very convenient. You know that.
I know, my lord. I am very sorry, but I'm not in town. I have a matter fixed here in Chennai at 12 noon, my lord.
Come back and appear.
My lord, can it be on the 11th of
August?
Yes.
Hey, order karo. Mr. Bhattacharya, learned senior counsel, appearing for the appellant, has appeared. Is there on the virtual mode? Stop. We don't find it convenient to hear him virtually. Stop. He requests us to post the matter on August 11, 2025. Stop. Let that be done.
My lord, may it retain its place. My lord, may it retain its place.
My lord, only one thing I must
Let that be done, retaining its position.
Grateful.
Because, my lord, which would be relevant, my lord, in my lord, has day application. My lord, not been included. So, my lord, we shall be relying on it. I'm just putting it on notice. They're all trial court records.
Why don't you prepare a
compilation, my lord, which we shall, my lord, depending on what they say. They might come that day and say they're not pressing a stay. They like the hearing of the appeal.
This is the order passed by a single judge of this court.
Yes.
আচ্ছা add করে দাও তো add করে দিন. Next.
My lord, the order here is from February. My lord, this is, my lord.
Ish. Cigarette.
My lord, gold plate, gold stack. This is the issue. Kindly have a look.
My respectful submission would be, my lord, it cannot be a suit for infringement, my lord, because I am also registered.
And passing off. And infringement of copyright. My lord, absolutely, my lord. My lord, I remember when we joined the profession, my lord, Mr. Gautam Chakraborty used to, my lord, always hand up the product and say the ocular test, kindly have a look at it.
Not Amrita. What was the case?
One of them.
Amrita.
But I would demonstrate, my lord, it's not a suit for infringement. It cannot be a suit for infringement.
Acha, ঠিক আছে. Mr. Mukherjee, learned senior counsel representing the defendants.
Plaintiff.
My lord, we succeeded.
Respondent oblique plaintiff says that the appeal papers do not include all papers that were available before the learned trial court.
My lord, some which were not there have been included, my lord, which we shall raise up.
But includes some papers which were not there before the learned trial court. Which in does not include all papers which were there, but includes some papers which were not there before the learned trial court. The respondent oblique plaintiff is permitted to file a bunch of the documents which have been omitted, which have not been filed with the appeal papers, and supply a copy of such bunch to the learned advocate for the appellant. Mr. Sinha is instructing you. Fairly long order. Where is he? He's disappeared.
It's just here.
Anything else?
My lord, in fact, my lord, if you're
Grateful.
for scrutiny, my lord, as to who's online, who else?
Yes.
Mr. Banerjee is online.
Sorry, my lord. I'm online today, my lord. I'm sorry. Which part of the world? No, my lord. This part of the world, my lord. Very well. 11th.
Grateful, my lord.
Grateful.
Item number 2. Appear, my lord.
Hmm?
Appear for the appellant petition. For the respondent. The delay of 24 days, my lord, in preferring the appeal. For the representative respondent. This is my affidavit in reply, my lord. One audit for condonation of delay application in this process. But the first one in this appeal.
Yes.
My lord, 24 days delay, my lord, in preferring the appeal.
Yes. What is your objection?
The third application for condonation of delay.
Maybe, Mr. Dey, but you should be knowing
I appreciate that.
our approach. Condon. Hey, শুনুন. This is an application. কোনটা এটা GA কত?
This is one.
I want. This is an application for condonation of delay of 24 days in presenting the appeal. Paragraph. Causes shown being sufficient, comma. The delay is condoned. Paragraph GA such and such is disposed of. এবারে শুনি. On merits, let us hear, Mr. Dey. Yes.
There is no other. Your lordship can dispose of the free application direction for filing a paper.
Oh, I
There
see.
is nothing. But decree has been satisfied. There's no. So no interim scope of interim order.
No.
This is the
Decree against you.
My lord, I prefer an application under Order 9 Rule 13. My lord, which was again my lord, there was a application of condonation of delay.
So it must have started with a suit against
Yes,
you.
suit. I was defendant number 2.
Yeah.
Summons not served.
You are the plaintiff.
Yes. Ex parte decree, summons not served. I file Order 9 Rule 13.
You are Sushil Kumar Moore.
Yes, my lord.
I see. So ex parte decree, Order 9 Rule 13 dismissed.
With before that, an appeal was preferred from the decree. An appeal court rejected the condonation of delay prayer and directed them. Asked me to go back, file Order 9 Rule 13, which I did. That was accompanied by application for condonation of delay. That was dismissed. Consequently, appeal dismissed. Order 9 Rule 13 dismissed.
So therefore, your appeal is against that order.
Yes.
Dismissing your condonation.
Condonation and consequently the Order 9 Rule 13.
Esho, Ashun.
Lordship, one thing, if the lordship dispose of the free application, the allegations made in the petition, and since I am not agreed.
How soon will you file your paper book? Informal paper book. All the respondents are represented.
The service is complete. One last occasion.
2, 4. You are 1.
He is Sonali Bank, I guess.
3 is absent.
Sonali Bank. But they have been served. The last order records that have been served. The affidavit of service.
তাহলে GA2 টা না GA2 কোনটা স্টে কোনটা?
They would be GA2.
GA2 টা along with the appeal নিয়ে লেখো. The appellant, which was the defendant number 2 in the suit filed by the respondent number 1 here, comma, has suffered a money decree. Stop. The decree was ex parte insofar as the appellant is concerned. Stop. The appellant applied under Order 9 Rule 13 of the Code of Civil Procedure for recall of the decree. Decree, stop. That application was dismissed. Stop. The appellant challenged such order of dismissal before the division bench by filing an appeal accompanied by an application for condonation of delay. Stop. The division bench dismissed the application for condonation of delay and consequently dismissed the appeal. Stop. No.
How come
No.
Prior to
Doesn't fit in.
Rule 13,
Yes.
prior to Order 9 Rule 13.
Oh, you had a. Oh, I see.
Prior to Order 9 Rule 13.
Right. I see. তাহলে এটা ভুল হয়ে গেল। He was ex parte. এটা বলা হয়েছে তো?
On the verge, not dismissed, sir.
concerned.
First you said dismiss, then it's on the verge of dismissal.
না না একদম গোড়ায় যান একদম গোড়ায়। Correct. Stop. না তারপর কেটে দিন। The appellant herein preferred an appeal against such decree and filed an application for condonation of delay in presenting the appeal. Stops. That application, that condonation application was dismissed, and consequently the appeal was dismissed.
No, my lord, liberty was granted to file a fresh application under Order 9 Rule 13.
Was he not dismissed?
I don't think so.
Not just record that you withdraw the appeal. I'll giving liberty to you to
That's
file an order 9
withdrawal.
Rule
How
13.
could that be dismissal? That's withdrawal.
After hearing of 3 days, the appeal court
No,
order,
no,
then you
no,
withdraw the
no.
appeal and file the order 9 Rule
Order
13.
9 Rule 13 টা dismissed হয়েছে। না ওইটাই সেই লিবার্টি বেসিসেই করেছিল।
Yes.
কি হলো তাহলে?
The appellant herein preferred an appeal against such decree and filed an application for condonation of delay
Stop. In presenting the appeal. Stop. তারপর কেটে দিন যদি কিছু বলে থাকি। The appeal court permitted the appellant to withdraw the appeal with liberty to approach the learned single judge with an appropriate application. Paragraph. Accordingly, the appellant filed an application under Order 9 Rule 13 for recall of the ex parte decree. Stop. That application has been dismissed by the impugned order. Is it correct now?
Yes.
Sure?
No, it's correct.
By the impugned order. Stop. There is no scope for passing any interim order. Stop. The appeal has to be heard. Paragraph. Let the appellant prepare requisite number of informal paper books.
The papers before the stay application.
Incorporating therein all papers that were available before the learned trial court. Trial court, which court?
Single judge.
Learned single judge. Learned single judge. Stop. All formalities are dispensed with. আচ্ছা ওইটা within fortnight, within 3 weeks.
2 weeks.
ওইটা হ্যাঁ ওটা ওখানে within 2 weeks. Incorporating all papers therein, which were there with before the learned single judge, comma, within 2 weeks from date. তারপরে ওখানটা all formalities are dispensed with. Top. Since the respondent numbers 1, 2, and 4 are represented through learned counsel, comma, notice of appeal is deemed to be waived insofar as those respondents are concerned. Stop. Issue notice to respondent number 3. Stop. Paragraph. The stay application stands disposed of. Stop. However, for the sake of convenience, comma, a copy of the stay application will be included in the paper book. List the appeal 3 weeks hence.
I'm grateful.
Since I have not used any affidavit, the allegations made in the petitions are not happening.
But you took direction. The stay petition, stay. As a stay petition disposed of করার আগে disposed of করে তারপরে add করে দিন. Since the respondents have not been directed to file affidavit in opposition to the stay petition, comma, the allegations in the stay petition are deemed not to be admitted by the respondents. ঠিক আছে তো প্রচুর গুলো এটা বলতে গিয়ে যাকে Yes. No. Just to tell you, a very long order has been passed. That was more for the benefit of your counsel.
The award holder, my lord, the respondent.
What percentage was flared up? 27.5. 28.4.
Led by Mr. Ratnanko Banerjee, my lord, he is online.
Yes, we just saw him about 7 minutes ago. in another matter. We saw him. He said he's in India. I don't believe him. Where is he? In Paris or
Close to the Bangladesh border.
Bangladesh?
Close to the Bangladesh border.
Oh, I see. Oh, I see. Circuit. Yes, Mr. Dotto, why is he going away?
Madam, Sina told you to go. No, this is not his
Which is your matter?
7 regular division.
Oh, regular division. Unlikely.
Matters in this court. I was next court too. I thought I'll just see what is.
Oh, thank you.
No, but
Kind of.
I told him that the moment you leave this court, I shall sit down. So that your matter will be called on. Well, on the last occasion, I placed the impugned judgment.
Yes, Mr. Mitra. Sorry. New York.
Only papers, I কাগজ নিয়ে পাগল হয়ে গেল অ্যাওয়ার্ডটা কোথায় অ্যাওয়ার্ডটা কি এর মধ্যে রয়েছে কম্পাইলেশন দেবে কোথায় আমারটা ইউজ না তোমারটা ইউজ করলাম এটা কম্পাইলেশন না নোটস অফ আর্গুমেন্ট না কম্পাইলেশন দেখো তো এর মধ্যে কোথায় কম্পাইলেশন আছে award বার করে গেছে My lord will be pleased to take the award. On the last occasion, I placed the impugned judgment and I made my submissions that the learned judge, as also my lord in the tribunal, proceeded on the basis of a document, well, considering it to be a part of the evidence. But I submitted to your lordship that it was really, my lord, a part of the argument, which by mistake, it's erroneously, it has been treated to be an evidence. And my lord, on the basis of that, my lord, award, the judgment has been passed.
The order of the Competition Commission.
The Competition Commission of India. My lord, I will request your lordship now to go to the award.
ছোট্ট কোম্পানি
কম্পিটিশন গেল কোথায় কারণ এর মধ্যে ঢুকে গেছে বোধহয়
Notes of argument of the appellant.
এর মধ্যে আছে
না CCI এর অর্ডারটা দাও এটা দাও appellant's notes of argument দাও
Well, we have given a compilation consisting of the purchase agreement, gas sale and purchase agreement, and the award put together for your lordship's convenience. If your lordship takes the award from there,
you want us to take the award? Oh, award. Sorry, তুই ঠিকই দিচ্ছিলে দাও
my lord would be pleased to come straight away to the award para 205. I am not troubling your lordship with the earlier part of the award. These are all questions of facts which have been gone into, rightly or wrongly. I am not going to question that. I cannot question these things. So, my lord, I am going straight to the paragraph 205, which will be in this compilation.
Turning page 99.
99. The claimant's relief. The next question is whether the claimant is entitled to any relief and to what extent. The claimant in SOC, that statement of claim, has prayed for specific performance of GSPA by seeking a declaration that GSPA dated 11th May 2011 is valid and subsisting and binding upon the parties. Admittedly, clause 15 of GSPA, under clause 15 of GSPA, the contract shall automatically continue up to 30th April 2034 and stand terminated thereafter. But the same has been terminated by the respondent by its notice dated 7 July 2014, with effect from 15 July 2014. This tribunal has held, for reasons discussed already, that such termination of GSPA by the respondent is wrongful and invalid. Then 206. In a legally binding contract, it is obvious that each party expects the benefit of the bargain which has been struck. In the event the contract is not performed and a breach is committed by one party, the party complaining of the breach has a right to recover compensation in the form of damages for the loss or benefit under the contract. Both the remedies of damage and specific performance are available upon the breach. The former is a substitutional remedy, whereas the latter, it should be latter, in a specific remedy. Both under English common law and Indian law, damages is a presumptive remedy, whereas the remedy by way of specific performance is granted by way of exception. It is well known that the remedy of specific performance is a discretionary one. In the instant case, apart from claiming specific performance of GSPA, the claimant has prayed for damages in paragraph 48, 49, and 52 and 53. It has also argued that its case for damage on account of MGO till the tenure of the agreement, that is April 30, 2034, pleaded in paragraphs 48, 52, and 53, which has not been denied. My lord, kindly note this. I'll have to take your lordship this. There's a specific denial of this, which has not been denied by the respondent in para 83 of the SOD. My lord, para 82, these particular paragraphs have been dealt with, but instead of referring to para 82, the learned tribunal had been pleased to refer to para 83 of the SOD. In para 52, it has been pleaded that even after termination of the contract by the respondent by its notice dated 7 July 2014, it has raised MGO invoices on it from 1st October 2014 for a sum of rupees 3 crores 93 lakhs 83,240. And for the quarter of October 2014 to December 2014, it raised MGO invoices for the sum of rupees 4 crores 58 lakhs 64,000. In para 53 of SOC, the claimant has pleaded that its claim on account of MGO quantity comes to a sum of rupees 396 crores 43 lakhs 22,880. That is up to, my lord, 2034. The claimant has raised some other claims in paragraph 54, 55, and 56, but since those claims pertain to applications filed before the Honorable High Court in connection with the civil suit and which was ultimately withdrawn, the tribunal does not deal with those claims. The claimant has also prayed for certain declaration and has also urged that the respondent cannot deny its obligation under the MGO clause in terms of GSPA. Considering the case of the claimant and the respondent and the materials on record and the conclusions which have been reached by the tribunal holds that the claimant is entitled to a declaration as prayed for in clause G, H, and I of its prayer clause at paragraph 63. If your lordship wants to look at it, then I can immediately refer your lordship.
You showed this to us. We have noted.
Yes. So I showed it to your lordship. But considering the nature of the contract, this tribunal in its discretion cannot grant specific performance of the same. The tribunal, however, permits the claimant to remove its underground gas pipeline from the premises of the respondent upon giving it 7 days clear notice. Well, I must frankly confess to your lordship that the award is written in a very felicitous language, as was expected from this tribunal. And so, my lord, it is easy reading.
Yes.
I mean, I must confess to your lordship this, my lord. It is an admitted position that CBM gas, being a natural product, cannot be stored. It has to be distributed to its consumer, or it had to be flared up. In the order of the CCI at page 67, it has been found factually, kindly note this, once the CBM is produced and if the consumer fails to take off the contracted quantity, GEECL has no option but to flare up the gas. There is no spot market for CBM gas where GECL can sell the gas which is not consumed by a customer. Then in para 41 of the said judgment of CCL, it has held further that GCCL has had to flare up 28.48% of the gas produced in 2015 and 16, as it had no market for the same in the face of competing products. So, my lord, this is the one of the foundation for the award which has been given. And it has been said that in para 41 of the judgment, CCI has found this, has held this. I am questioning this. And I have shown to your lordship that this is not really a finding. It was a part of the submission of the of my lord, the respondent. Then your lordship will please to come to the next page. These findings of fact, kindly note the next paragraph. These findings of fact were also affirmed by the High Court as noted above. I shall show to your lordship, my lord, the High Court did not even mention this 28.47. There is not a whisper of it. Subject to correction by my learned friend, I could not find anything. The learned counsel for the respondent has not questioned such findings. My lord, this is another thing, my lord. This is where, my lord, I think the whole thing has gone wrong. The learned counsel for the respondent has not questioned such findings of fact and argued on the basis that the said findings are binding on this tribunal. In fact, the learned counsel for the respondent has no choice other than accepting that the finding of fact by the CCI is binding in view of Section 61 of the Competition Act, which excludes civil court's jurisdiction in respect of any matter which the Commission of the Appellate Tribunal is empowered under the said Act to determine. Well, I will request your lordship to take, my lord, the Competition Act once. Here again, I say that perhaps this is not correct. I will request your lordship, my lord, to take the competition if your lordship
Yes, yes.
if
আমরা
not,
দেখেছিলাম।
I got the copy.
নাকি ওরা দিয়েছিলেন মনে নেই। এই
I am pausing here for a moment for the purpose of, my lord, making my submission on the Competition Act. এখানে আছে বলে মনে হচ্ছে না। এইটাই আছে 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 এইটাই এইটাই দেখি এটা ঠিক না না কম্পিটিশন কপি আছে নেই না but 2 copies are there, lordship. My lord, kindly see if your lordship has got, my lord, if your lordship has got the statement of objects and reasons at the beginning. Paragraph 3, I shall refer your lordship to and then take your lordship to a few of the sections. Paragraph 3 of the objects of statement of objects and reasons It starts with the Competition Bill of 2001. Kindly see the object. Seeks to ensure fair competition in India by prohibiting trade practices which cause appreciable adverse effect on competition in markets within India, and for this purpose provides for the establishment of a quasi-judicial body to be called the Competition Commission of India, which shall also undertake competition advocacy for creating awareness and imparting training on competition issues. Now, let kindly come to a few of the sections. Kindly come to section 4. What is being prohibited by the Act? And to what extent the court can rely upon the findings on the basis of the orders passed under the Competition Act. Abuse of dominant position. No enterprise or group shall abuse its dominant position. There shall be an abuse of dominant position under subsection 1 if an enterprise or a group A directly or indirectly imposes unfair or discriminatory condition in purchase or sale of goods or services, or the price in purchase or sale, including predatory prices of goods or services, then limits or restricts the production and indulges in practices. My lord, your lordship will be pleased to see a complaint was made in the facts of our case by one of the employees of my client. Well, the allegation was that he was set up, maybe so. And my lord, that particular man complained of this particular agreement. It was alleged in this that this particular agreement was, my lord, brought into existence by way of undue influence. And one person, that person, the respondent, was in a dominant position.
That is you. That is you.
That no, them, the respondent, was in a dominant position to control, and my lord, they manipulate this particular agreement in their favor. And that was the complaint, and that was why it was sought to be challenged that before the Competition Commission. And that was, first of all, it was, my lord.
And their employee made the complaint.
One of my employees, my lord, made the complaint. And my lord, the allegation was that he was set up by my client. I'm not going into that question. And my lord, that particular complaint did not meet with success in the Competition Commission. Matter went to the Delhi High Court under the provisions of this Act. And my lord, the Delhi High Court also rejected that contention. So the contention was challenging the agreement on the ground that the respondent was in a dominant position to influence, my lord, to persuade the claimant was in a dominant position to persuade the respondent to enter into this, and therefore this is something, my lord, contrary to Competition Act, then therefore this particular agreement should not be given effect.
If this is for my education,
yes.
If the CCI comes to a finding that indeed the agreement is unfair, it can cancel the agreement. It has the power. It has the power.
Yes, it can declare it to be so. Of course, the appeal lies to the High Court and to the Supreme Court, but they have got this power. And my lord, kindly see the dominant position has been defined under the explanation. And these have been considered in the Competition Commission's order. I shall come to that. Then, my lord, kindly come to section 19. And this was the inquiry which was lodged. Section 19. Inquiry into certain agreements and dominant position of the enterprise. The Commission may inquire into any alleged contravention of the provisions contained in subsection 1 of section 3 and subsection 1 of section 4, either on its own motion or on receipt of any information in such manner and accompanied by such fee as may be determined. Then B, a reference may be made to it by the central government or a state government or a statutory authority. Then subsection 2, without prejudice to the provisions contained in subsection 1, the powers and functions of the Commission shall include the powers and functions specified in subsection 3 to 7. Kindly see the powers. Subsection 3. The Commission shall, while determining whether an agreement has an appreciable adverse effect on the competition under Section 3, have due regard to all or any of the following factors. A. Creation of barriers to new entrants. B. Driving existing competitors out of the market. C. Foreclosure of competition by hindering entry into the market. D. Accrual for benefits of consumers. Then E. Improvement in products and distribution of goods or provision of service. Then F. Promotion of technical, scientific, and economic development by means of production or distribution of goods or provision of services. Kindly see, my lord, the nature of the inquiry that is to be made. Then the Commission 4 is, the Commission shall, while inquiring whether the enterprise enjoys a dominant position or not, under Section 4, have due regard to all or any of the following factors: market share, size and resources, size and importance of competition, economic power of the enterprise, vertical integration of the enterprise, etc., my lord. Then, my lord, the various, my lord, provisions are there with regard to subparagraph, kindly comes to subparagraph 5. For determining whether the market constitutes a relevant market for the purpose of this act, the Commission shall have regard. Then 6. The Commission shall, while determining the relevant geographic market, have due regard to all or any of the following factors: regulatory, trade barriers, local. The inquiry, what I'm submitting before your lordship is, the inquiry and investigation under this act is totally different from, my lord, adjudication before a court of law. This is a specific, my lord, specialized commission has been constituted for the purpose of determining these only. Then, my lord, what the commission shall take into account is subsection 7. Physical characteristic or ends of the goods, price of the goods, consumer preferences, exclusion of in-house production, then inquiry into the commission, etc. Then, my lord, reference, the commission can make a reference also, section 21A. Then your lordship will please to come to section 26. Procedure for inquiry under section 19. On receipt of a reference from the central government or state government or a statutory authority, or on its own knowledge or information received under section 19, if the commission is of the opinion that there exists a prima facie case, it shall direct the Director General to cause an investigation to be made into the matter. In fact, in our case, in this case, the Director General was appointed and he made an inquiry, and the report went in favor of the appellant before your lordship. Against that, my lord, they went before the commission, and the commission reversed that. And it was held that there was no, my lord, infraction of any of the provisions, and therefore dismissed the complaint. From that, my lord, the matter went to the Delhi High Court. Delhi High Court also dismissed this. Now, my lord, I am not troubling your lordship with the nature of the inquiry that is there. And, my lord, your lordship sees the orders by commission after inquiry is section 27. This is the jurisdiction of the commission. Orders by commission after inquiry into agreements or abuse of dominant position. Where after inquiry, the commission finds that any agreement referred to in section 3 or action of an enterprise in a dominant position is in contravention of section 3 or section 4, as the case may be, it may pass all or any of the following orders, namely, direct and any enterprise or association of enterprises or persons or association of persons, as the case may be, involved in such agreement or abuse of the dominant position to discontinue and or to re-enter, not to re-enter such agreement or discontinue such abuse of dominant position, as the case may be. Then B, impose such penalty as it may deem fit, which shall not be more than 10% of the average of the turnover, etc. I am not troubling your lordship. Then provided that in case any agreement referred to in section 3 has been entered into by cartel, the commission may impose upon each producer, seller, distributor, trader, or service provider included in the cartel a penalty of up to 3 times of the profit for each year of the continuance of such agreement or 10% of its turnover for each year. Well, these are the, or pass, my lord, G. Pass such order or issue such direction as it may deem fit. So a complete discretion is there as to what order is to be passed. Then, my lord, kindly come to section 61. Before that, my lord, kindly come to section 53A. This is the appellate tribunal. Establishment of appellate tribunal. I am just indicating to your lordship. Then appeal to the appellate tribunal 53B. Then composition of the appellate tribunal. These were, my lord, exhausted in the facts of this instant case. Then, my lord, kindly come to section 61. And this section has been referred to and relied upon by the tribunal in the instant case. Tribunal meaning thereby arbitration tribunal. Exclusion of jurisdiction of civil courts. No civil court shall have jurisdiction to entertain any suit or proceeding in respect of any matter which the commission of the appellate tribunal is empowered by or under the act to determine, and no injunction shall be granted by any court or other authority in respect of any action taken or to be taken in pursuance of any power conferred by or under this act. So, my lord, no civil court shall entertain any proceedings in respect of any matter which the commission of the appellate tribunal is empowered by or under this act. My lord, therefore, I respectfully submit to your lordship that perhaps my lord, the application of section 61 at page 102 by the arbitration tribunal was not quite correct. Kindly, my lord, come back to paragraph 212 of the award. 212. These findings of fact were affirmed also by the High Court as noted above. The learned counsel for the respondent has not questioned such findings of fact and argued on the basis that the said findings are binding on this tribunal. In fact, the learned counsel for the respondent has no choice other than accepting that finding of fact by CCI is binding in view of section 61 of the Competition Act, which excludes civil court jurisdiction in respect of any matter which the commissioner of the appellate tribunal is empowered under the said act to determine. Therefore, my respectful submission will be, unless your lordships find that this finding of 28.47% or whatever it is the flare up, that is a finding of fact. First of all, it has to be a finding of fact to be able to make it binding. I say that it is not a finding of fact, therefore it is not binding. Secondly, assuming that it is a finding of fact, my respectful submission will be, this is not one of them in a matter in respect of which, my lord, the commission of the appellate tribunal has exclusive jurisdiction. Their jurisdiction is, my lord, is contained, my lord, in section 5, 6, etc. There, my lord, there is no question of finding of fact with regard to flaring up. In any event, I say, even assuming that it is a finding of fact, that will have no effect upon the tribunal, arbitration tribunal, particularly when the arbitration tribunal has been specifically, my lord, enjoined to come to a conclusion with regard to this finding. This, my lord, I respectfully submit to your lordship. First is that it is not a finding of fact. Secondly, assuming it is a finding of fact, it has got no binding effect upon the tribunal. The tribunal had, my lord, in my respectful submission, with the greatest of deference to the, my lord, the arbitral tribunal, they have completely gone wrong in thinking that this is, my lord, the last word insofar as they are concerned. And it says, it goes without saying that if civil court cannot question the finding of fact, again, by the CCI or the appellate tribunal, this tribunal is also unable to do so. I say, my lord, this is the foundation of, my lord, the claim for damage. And if this is wrong, then perhaps, my lord, if the foundation is wrong, then the edifice cannot stand on that. My lord, kindly come to para 213. As against the aforesaid case made out by the claimant and its case of unpaid MGO bill in paragraphs 48, 52, and 53 of SOC, the respondent, while dealing with the aforesaid paragraphs in SOC, in para 83 of SOD, did not dispute that MGO bill were raised by the claimant even after alleged termination of GSPA by the respondent. Apart from that, in para 83, there is bare denial by the respondent of the case made out of the unpaid MGO bill of the claimant in para 48, 52, and 53 of SOC. I stop here for a moment, my lord. I'm sorry, my lord. I'll have to take your lordship now to look into the averment made in the statement of claim and, my lord, the denial made in the respondent's statement of defense. There, if your lordship looks into it, these short paragraphs are there. If your lordship looks into it, I will submit to your lordship that on the basis of these pleadings, issues would have been raised with regard to whether damage has been suffered by them, what is the quantum of damage, and whether in terms of, my lord, under the Contract Act, they are entitled to claim this damage. These issues should have been framed, should have been answered. Issues have not been framed, have not been answered. So as a result of which, my lord, I find that there is an utter confusion in the matter of, my lord, assessment of what has been said in the statement of claim and what has been contained in the statement of defense. My lord, kindly, my lord, take in this connection the statement of claim once. This your lordship will please to find in volume 1. Volume 1, I would request your lordship to come to page 31. Paragraph 47. My lord, may I place before your lordship two or three paragraphs, 46, etc. I am confining myself entirely to the issue of damage. Kindly come to para 46 at page 31 of the paper book. The purported termination of the agreement dated 11th May 2011 is wrongful and illegal, null and void, and is not binding or operative upon the parties. The respondent was under a duty and obligation to comply with the terms of the agreement for sale and supply of CBM gas. Thus, the claimant is entitled to enforce specific performance of the agreement dated 11th May 2011. The claimant states that CBM gas is not an ordinary article of commerce, and the claimant has to make arrangement for supply of CBM gas to the respondent's factory and works. The claimant does not have readily available market for supply of such minimum quantity of CBM. A specific allegation: the claimant does not have readily available market for supply of such minimum quantity of gas of CBM gas, and as such, the respondent is under an obligation to accept the supply of CBM gas for the minimum quantity for the balance period of the agreement. This is the foundation of their claim. Their foundation of their entire claim is this allegation. This has been denied. If this has been denied, they are obliged to prove it. Onus is upon them that they did not have any market, they could not sell it. On the contrary, on this particular aspect of the matter, we had laid evidence. I shall show to your lordship that, my lord, they had a market, they had sold it, and, my lord, they had 2 or 3 months during which this happened. And my lord, we showed that. And that was not considered by the learned tribunal. I shall show to your lordship what the tribunal has said with regard to it. Then, 47. Further, in the alternative and strictly without prejudice to the claimant's right to enforce specific performance of the agreement, the claimant is also entitled to claim loss and damage suffered by the claimant for the wrongful, illegal, and termination of the agreement by the respondent letter dated 7 July. But I say this, I'm very respectfully submitting that what we have learned from the very first day in our profession, that a person who makes the allegation will have to prove that. And this is the allegation they have made. Whereby they have suffered damages. Well, the issue would have been this: did the claimant suffer any damage by reason of the alleged wrongful and illegal termination of the contract? So, the onus was upon them. And I shall show to your lordship this has been denied. The claimant estimates such loss and damage as the amount payable for the MGO under the agreement, payable quarterly for the remaining period of the agreement, that is with effect from 6 hours, July 14, 2014 till midnight of April 30, 2034. This is the claim. So, my lord, for 20 years they have claimed this amount. And then, my lord, the quantification of the claim in para 48. And my lord, this I am respectfully submitting. This has been dealt with in, my lord, the paragraph in the counter statement of facts. I shall give your lordship the paragraph of that. My lord, that will be in volume 2, page 211. Volume 2 to the page 211. This is a long paragraph. In fact, if your lordship, my lord, takes page 208, paragraph 82 is dealing with paragraphs 36 to 48. Kindly come to page 208. With reference to the contents of paragraph 36 to 48 of the statement of claim, it is stated that when the matter was taken up on 11 July 2014, the learned counsel appearing, I am not troubling your lordship with this. This is with regard to paragraph 36, my lord, onwards. And my lord, every line has been dealt with here, and a lot of things have been said with regard to what happened in the transpired in the court of law. When, my lord, the application was made, interim applications were made. I am not troubling your lordship with this. Kindly come to paragraph page 211. Dealing with that paragraph, the paragraph 47 and 46, 47. Page 211, about the middle of that page. It is, your lordship will find it, it is denied that the claimant does not have a market supply. It is denied that the claimant does not have a market for supply of CBM gas, or that the respondent is under an obligation to accept supply of gas from the claimant. It is denied that there is no minimum quantity of gas supply, or that there is any balance period as alleged or at all. It is denied that the claimant is entitled to any claim on account of loss or damage, or that any loss or damage has been suffered by the claimant, or that there has been any wrongful or illegal termination of the agreement by the respondent, or that the claimant has any estimate or has suffered any loss or damage, or that there is any amount payable under the said purported MGO, or that any amount is payable till 2034 as alleged or at all. The purported MGO clause has been abrogated. Allegation, I am not troubling your lordship. Then your lordship will please to, the learned tribunal has been pleased to rely upon para 83, which was not dealing with my lord the of damage. Damage has been claimed in para 46, 47, 48 of the statement of claim I just now showed to your lordship. That has been dealt with in para 82, not in para 83. And my lord, throughout this, I submit to your lordship that had it been a suit, then on the basis of this allegation in the statement of claim and the denial in the counter statement of facts of the statement of defense, issue would have been raised. Did the claimant suffer any loss or damage as alleged in para 46, 47 of the statement of claim? And if so, what amount? That would have been the, my lord, in my very respectful submission, that would have been the issue which would have been raised. In which event, my lord, if that issue had been raised, then I would have been they would have been entitled to raise, my lord, lead evidence for the purpose of showing that the damage they have suffered, and I would have been entitled to, my lord, lead evidence for the purpose of showing that they had not suffered any damage. And because, my lord, they have sold it to third parties in the meantime. And the issue of mitigation of damage would have come in straight away. This, my lord, had been ignored by the court. Now your lordship again comes back, my lord, to the award. Lordship has been pleased to see that yes, kindly come to the award once more. Page 100. I'm just referring your lordships back to this paragraph. Page 207, paragraph 207, kindly comes to this paragraph once more. See, see the second sentence in para 207. It has also been argued that it's a case for damage on account of MGO till the tenure of the agreement, that is April 30, 2034, pleaded in paragraph 48, 52, and 53, which has not been denied by the respondent in para 83 of SOD. Para 46, 47 had not been referred to, para 82 had not been referred to. And then again, my lord, in para 52, it has been pleaded that even after termination, it has been said. Then again, my lord, kindly come to para page 102, para 213 of the award. As against the aforesaid case made out by the claimant, and in the case of unpaid MGO bill, paragraph 48, 52, 53 of the SOC, the respondent, while dealing with the aforesaid paragraphs in SOC, in para 83 of the SOD, no mention of para 82, no mention of para 87, 47 and 48 of the statement of claim. Then, my lord, kindly comes to paragraph 213, 214, sorry, 214. The arbitral tribunal has to decide the case of the parties on the basis of the statement of claim and defense. Section 23 of the Arbitration and Conciliation Act provides the claimant shall state the facts supporting his claim, the points at issue, and relief or remedy sought. Therefore, the claimant has to state these facts. And the respondent shall state his defense in respect of these particulars unless the parties have otherwise agreed. And this is exactly what I have done. I have raised my defense. Kindly see, my lord, what the court has said in the page 103, 215. Following the aforesaid legal position, this tribunal has to decide the claim of the claimant on the basis of the pleadings between the parties. The respondent, in course of his argument, sought to urge on the basis of its written note, part 4, that the claimant has not suffered any loss by way of flaring up, and they have referred to returns filed by the claimant with the Directorate of General Hydrocarbons, Ministry of Petroleum and Natural Gas. But in its SOD, kindly note this, the respondent has neither referred to nor disclosed these materials. Do I have to do that? I never knew that I had to disclose my evidence in my pleading. It is well settled that the facts on which there is no pleading, no evidence can be adduced. Even then, it shows from the chart produced by the respondent that there is flaring up. This tribunal is unable, for the reasons discussed above, to accept the respondent's attempt to contradict the finding of the CCI. This tribunal is unable, for the reasons discussed above, to accept the respondent's attempt to contradict the finding of the CCI that GECL had to flare up 28.48% of the gas produced in 2015-16, as it had no market for the same after the respondent terminated the contract in July 2014. This is, my lord, the basis of granting of damage. Huge amount of damage has been given.
58 crore? No, কত জানো এটা?
Yes, about that. That the 15% of that amount calculated on the basis is simple arithmetic. The quantum of gas that was to be supplied 2034, 15% of that, relying upon, my lord, Kailashnath Associates and, my lord, the other judgment and this judgment. Your lordship will kindly come to the next paragraph. The respondent has also relied on the judgment of the Supreme Court in case of Kailashnath Associates versus Delhi Development Authority. In that judgment, the learned judges of the Supreme Court, I shall rely upon this judgment, I shall show to your lordship. The Supreme Court held in para 33 that section 74 of the Contract Act is sandwiched between section 73 and 75, which deal with compensation for loss and damage for the breach of contract, which a party may sustain through non-fulfillment of the contract, after such party rightfully rescinds the contract. The court held compensation is payable for the breach of contract under section 74 only where damage or loss is caused by such breach. Relying on the aforesaid observation of the learned counsel for the respondent urged that in this case the claimant has not suffered any loss. But the contention is clearly contradicted by the factual finding of CCI again, that GECL had to flare up 28.47%, 48% of the gas produced in 2015-16, as it had no market for the same. Therefore, the principles reiterated in Kailashnath have been satisfied in view of the aforesaid finding of the CCI.
We'll come back.
Lordship.
4.5 minutes.
Yeah, Lordship. My lord, kindly take section 23 of the Arbitration and Conciliation Act. Statements of claim and defense. This has been quoted. Kindly see. Within the period of time agreed upon by the parties or determined by the arbitral tribunal, the claimant shall state the facts supporting his claim. So the claimant first will have to state the facts supporting his claim, the points at issue, and the relief or remedy sought. And what the respondent is to do, the respondent shall state his defense in respect of these particulars, unless the parties have otherwise agreed. Therefore, if the claimant says, I have suffered loss and damage to the extent of rupees 53 crores, and the defendant says, no, you could not have suffered loss and damage because you had sold it to other parties, then, my lord, an issue is raised, and I am entitled to, my lord, urge my point of defense. This point of defense, my lord, I was not allowed to urge because of, my lord, the finding of the learned tribunal at paragraph 214 and 215. Sought to urge on basis of the written note. No, not on the basis of written note, part 4. The written note, my lord, which was submitted was on the basis of what has been led by way of evidence. What have we said? We, my lord, led evidence, my lord. I shall show to your lordship immediately before I take your lordship into any other thing. Kindly, my lord, take this. We have, my lord, collected together.
There was no witness action in this case.
Yes.
There was.
Witnesses were there. These witnesses were ignored.
Yes, good, yes, good.
The notes of argument কোথায় গেল?
Those documents were produced through the witness.
Yeah.
Mr. Mitra, those documents were produced through the witness.
Yes. Yes. But I have, my lord, in my submission, my lord, there is a voluminous, they are there already on record. My lord, in my notes of submission, my lord, I have annexed the extracts from the affidavit of evidence of my witnesses, cross-examinations made.
Notes of argument.
But the tribunal says you only annexed it with the written notes.
No, no. This is, I was surprised. I was very surprised, my lord, when I read it.
Exhibited.
These are exhibits. Marked exhibit. And here, my lord, the perversity has come in. Judgment है को तो होंगे नोट तक होते এটা দাও তো 2004-5 Supreme Court cases আরেকবার দাও 5 Supreme Court cases আমি জাস্ট একটু করে দিই আমার কাছে রয়েছে My lord, will your lordship, my lord, kindly take, my lord, the notes of submissions argument on behalf of the appellant? I shall give your lordship, I shall show to your lordship the evidence which was led. ঠিক আছে
আমাদের আগের বেঞ্চে
Page 74 of this. না সেটা সেই অ্যাফিডেভিট প্লেস করলেই তো হবে, তো সেই জন্য তো প্লেস করছি। তুমি তোমার ইয়েটা দেখো একটু, আমাকে বার করে বলে দাও তাহলে ঠিক মতো, আমি আমার নোট অনুযায়ী করছি। Lordship, kindly give me one second, my lord. এটা কার এভিডেন্স? RW4 এর নাম কি? বার করে দাও, RW4 এর এভিডেন্সটা বার করে দাও। My lord, kindly come to page 74. This is the affidavit of evidence of with respondent's witness number 4.
Our authentic is very bad.
এইখানে এক্সিবিট গুলো করা আছে, প্যারাগ্রাফ 86 and 87 of AOA,
Page
29.
My lord, kindly come to, by Lord Julian rightly points out, before I take your lordship to my lord that, kindly come to page 29. This is, my lord, the affidavit of evidence of এরকম ভাবে স্বর্ণ ছড়া করে লাগানো হয়েছে।
রেলেভেন্ট পার্টটা দিয়েছি, পুরো অ্যাফিডেভিটটা তো আমাদের পেপার বুকে লাগানো আছে।
Lordship will please to come to page 29. Lordship will please to come to paragraph 86. তার আগে তো ইয়ে রয়েছে, এই of CW1. My lord, this we shall give you, lordship, the reference of the paper book. My lord, this is the extract from the affidavit of evidence of RW4. Kindly come to para 85. The contractual rate for supply of CBM gas to the respondent was rupees 21 per SCM, which was valid up to May 20, 2015. Yes. Which included royalty of so-and-so and, my lord, production level payments of 2.5%. Then 86. From the reports of CARE dated October 24, 2014 and November 2015, and of CRISIL dated 11 February 2014, it is now clear that the claimant was not in a position to meet the demand of his clients. From these reports, it would be evident that the claimant had entered into commitments far exceeding its production capacity. The respondent has also got engaged the service of CARE and CRISIL for credit rating and for its bank loan purposes. I am fully aware of the system followed by CARE and CRISIL for rating its clients. In course of my searches on the respective website, I was able to obtain the procedure followed by both CARE and CRISIL for credit rating of their clients. I have downloaded the procedure from the website of CRISIL and CARE, respectively. Copies whereof are tendered in evidence and may be marked as Exhibit EFFF and EGGG, respectively. I have downloaded the said documents from the computer belonging to the respondent's office at Khetrodash Lane. This computer from where the said procedures were downloaded is regularly used in store, well, at the usual pleading of Section 75 of the Evidence Act. I have personally downloaded and printed these procedures. What both CARE and CRISIL do is to send questionnaire to its client, which has to be filled up by the clients. And thereafter, in course of one of the meetings with the client has to substantiate the commitment to the concerned credit rating agency. After credit rating agency is satisfied with the particulars so provided by the client, the same would be taken into consideration. Then, my lord,
page 32 তে চলে
no. Then, my lord, the reports of the para 88 is the reports which the respondent had obtained from CARE and CRISIL on a regular basis have been used by the respondent in connection with the credit facilities, etc. And then, my lord, as far as I am aware, it is mandatory for credit rating agencies like CARE and CRISIL to make available to the world at large the reports which they submit to the clients, similarly SEBI, etc. Then, my lord, kindly come to your lordship will please to come to paragraph. Yes. This is how, my lord, the crisis and care, my lord, reports were put into the evidence. Then, my lord, RW2, the second witness, at page 32.
Page reference to
These witnesses were cross-examined.
These were his witnesses were cross-examined. Yes, of course.
RW4 টা আগে বলে দিন এই পেজে আছে
My lord,
volume 18
this RW4, which I just now showed to your lordship, this will be in volume
18
Roman 18, page
2592
2592. Just, my lord, for your lordship's kind reference, 2592.
It starts with 2592 ends at
2700.
no it's
Volume 18.
Volume 18.
How many volumes you have?
There are 49 volumes I have found.
That is why we have prepared the notes and the excerpts are we have annexed here, like a convenience.
I am just giving your lordship that these are already on record. Just for your lordship's reference, can you just make a reference of it? That this is the affidavit of evidence.
It starts with 259
And the cross-examination of data.
and all includes
That, my lord, kindly, my lord, just make a note of it. Volume 18, pages 2592 to 3065.
volume
Evidence, affidavit evidence, and cross-examination.
volume 21. It ends at 21.
3065.
Ends at
3065 ends at volume 21. Ends in volume 21. Extensive cross-examination which has been totally ignored. I could have understood, my lord, you take note of it and then you say, no, this is not reliable, therefore I am rejecting that. Then, my lord, I wouldn't have been able to question that. But you don't take note of it at all. And this time and money has been spent in, my lord, putting the witnesses into the box. My lord, affidavit evidence.
Witness 2 starts with 12, ends at
My lord, affidavit evidence and, my lord, cross-examination of witness number 2 of the respondent, or the rather appellant before lordship, starts in volume 12 and ends at volume 18. This thick, my lord, examination, cross-examination. I mean, why these things have been done, I don't know.
1705 to 2565.
1705 to 2565.
You should have added one more volume. It will become a half century.
Yes, well, half century, my lord, we just missed. Then your lordship panel kindly come to page 32 of the extract of the RW2's cross examination in chief. Kindly see. Now, whether this is, my lord, acceptable or not.
This is paper book and sorry, yes, paper book page number RW2.
RW2 page 32 এটা কোথায় 7.1 না না 1705 না এইটা কোথায় আছে কোন ভলিউমে কোন পাতায় এই যে প্যারাগ্রাফ 7 এটা রয়েছে কোন ভলিউম 12 থাকা উচিত দেখো না তাহলে পাতাটা দিয়ে দাও 1711 well this is volume 12 page 1711.
We have mentioned it.
Sorry, volume
12.
We have mentioned in the note.
You mentioned?
In the note we have mentioned. Your lordship can kindly make a note of it at the top. Then it will be easier for your lordship to find out.
Yes. Lordship says page 3 of the note, we have given the reference.
Here the excerpts are given. In the note, references have been given.
Page 3, first paragraph, we have said reference may be made to. Number 1 is para 86 to 90 of AOE of RW4. Paper book volume.
Yes.
Page number certain.
So it is there. I'm just drawing your lordship's attention. This evidence was there. Kindly come to para 7 at page 32. In course of further searches, Through internet, I was able to obtain reports of the rating agencies CARE and CRISIL engaged by the claimant for rating its business. I have downloaded these reports from the website of Crisis and CARE, respectively. Copies whereof are annexed here too. I have downloaded the said documents from the computer belonging to the respondent situated at so-and-so. This computer was so-and-so. Then, my lord,
actual reportটা যেটা exhibit হয়েছিল
your lordship will please to come to page 33. This is the exhibit EQ, which is, my lord, the part of the crisis report. And here, kindly come to the last paragraph of that page. Last paragraph. GECL operating income grew 61% CAGR over financial year 11-12 to 1.6 billion, primarily due to increase in production volume, given by an increase of the number of producing wells.
Last paragraph.
The last paragraph at page 33.
Income grew 61%.
Yes, operating income grew. Then, my lord, producing for financial year 13 as a whole, the EBITDA, this is, my lord, earning before interest, tax, and amortization. EBITDA is, my lord, earning before interest, tax, and amortization. Margin improved to 64% from 45%. My lord, this has been a bit smudged. In financial 2011, so, your lordship gets that as increase in revenues absorbed fixed costs. PAT turned positive. PAT is, my lord, profit after tax. Profit after tax turned positive for the first time at 358 million rupees on the back of strong growth of EBITDA. EBITDA again, my lord, earning before interest, tax, and amortization. Despite an increase in depreciation charges and interest costs. ROE, that is return on equity, সব তোমাদের এগুলো abbreviation গুলো আমি বুঝতে পারি না। ROE, the return on equity for the year was low at 12.9%, as more than 50% of the wells drilled are the dewatering stage and thus not producing gas. CRISIL research expects ROEs to improve going ahead on the back of increase in the ramp of production from existing wells as well as increase in the number of so-and-so. But
page 36
then, my lord, kindly come to page 36. At page 504, the running page 504 of the notes of argument. I'm not troubling your lordship with that. আমি জানি সমস্ত মার্ক করা রয়েছে আমার। পয়েন্ট আউট করে যেগুলো আমি ভুলে যাব। Page 36. Page this is correct. Considering my age, my learned juniors always feel perhaps, my lord,
much better prepared than we are.
The lordship will please to come to page 36, my lord, last paragraph. Presence in an industrial belt with high energy demand. GECL's operational Raniganj South Block is situated in the vicinity of Asansol, Raniganj, Durgapur industrial belt. These cities have industrial activity with significant fuel demand, such as steel plants, carbon black, glass, and chemical industries. Prominent companies in the vicinity include ISCO Steel Plant, Durgapur Steel Plant, and Alloy Steel Plant of SAIL. Besides Alstom projects, Graphite India Limited, Philips Carbon Black. As of March 2013, the company had aggregate commitment to purchase 420 mm SCM of CBM as against 80 mm CBM on production of financial year 2013 as per DRHP.
5 times its production capacity.
So, my lord, kindly see selling commitment was 420 mm SCM of CBM as against only 88 mm CBM of production. So I say that whether this is correct or to what extent you rely upon it is entirely up to you. I am not going to question that. But then again, before you reject it, before you ignore this evidence, you must give the reasons for that. And what is the reason? That I have not pleaded this.
No, but Mr. Mitro, if you look at para 215 of the award,
Yes,
at page 10, internal page 85 of the award,
Lordship.
the tribunal considers the period 2015-16, during which 28.5% gas had to be flared up.
That's right.
What you have just shown us is financial year 2013.
Yes, quite.
So that figure, if you can show us for 2015-16, that the production capacity was much less than
My lord,
the market demand.
This is what I am seeking to show from the report itself. Well, these reports were the things which were produced before the tribunal for the purpose of, my lord, establishing the fact that what you have been producing and giving to me after this supply ceased to me, the supplies you went on making is much more than what you had been giving to me. Then how could you have supplied any loss or damage? This flaring up story, it gave me this impression that this is a particular consumer, my lord, consumer product, but particular consumer identified product. It goes to X and to nobody else. This has been done only for you. I have laid these pipelines only for you. I have invested this amount of money for the purpose of supplying to you only. Now, because I am not being able to supply to you, therefore I am burning off. I am flaring up.
Because it can't be stored and there is no other consumer.
No other consumer. I am showing, my lord, from these reports that after you ceased to supply me, you became richer. More supplies were made. And my lord, this particular report had given the number of projects which were there, to whom, my lord, the supplies could have been made.
Anyway, for whatever the reports are worth, they should have been considered.
Consumption, the clearing was less.
Whether you accept those reports
Period was July, we terminated.
It was based upon what? Evidence.
Evidence.
সেইটা what?
That's
এইটা
good.
দাও, তারপরে আমি
রেটিং এ এই যে বলছে না ফাইন্যান্সিয়াল ইয়ার 15
আগে ক্রাইসিল রেটটা করে নি, তারপরে আমি my lord, ক্রাইসিল rating, my lord, kindly come to page 37 now. Very well, kindly come to page 36 bottom. Expansion by sale to augment demand. Sale steel plant in Asansol, Raniganj, Durgapur belt are expanding, which should increase demand for gas in area as the new units are designed to use gas fuel. For instance, ISCO, a customer of GECL with gas offtake of so-and-so MMCM, is one of the biggest steel players in the region and has undertaken an expansion of so-and-so billion to upgrade its sellable steel capacity. Post-expansion expected to be completed by July, gas requirement is expected to close at 146 SCM. Similarly, alloy steel plant of SAIL has entered into MOU with KOBE Steel of Japan to set up a new unit expected to start by financial year 2016. The expected gas requirement from this unit is 110 SCM. Then lower competition in the region and the fact that gas is cheaper than other substitute fuels. Then gas availability of Asansol, Raniganj, Durgapur belt is currently low as the development of awarded fields to players such as ONGC, SR Oil, etc. has been slow. Thus, the past 5 years, GECL's Raniganj South Block has remained the only commercially producing CBM block catering to this industrial belt. Even the supply of natural gas from other gas producers such as RIL, ONGC, GSPC, Cairn, Oil is expected to be minimal because these players have minimal surplus gas to sell and there is no existing pipeline grid network that can serve the Asansol Durgapur region. What is being said here is, as far as I can see, is this that so far as GECL's production is concerned, my grievance is this: why should you not take note of these things? And at least, my lord, the onus should have shifted upon, my lord, by the claimant, that these are being produced. What do you say with regard to that? Because after all, today you are going to slap a huge amount of damage on a person, saying that by reason of your default, this is the quantum of damage suffered by this particular party. And if that particular party is shown by these reports to have been selling it to others, then should that not have been taken note of? You reject it, take note of it, and then reject it for whatever may be the reason. But
no reference in the award at all.
No. That is the paragraph. Your lordship has been pleased to see. The paragraph is this: that since the pleading is not there, therefore I am not going to look into this. And huge amount of evidence has been gone in. Then why did you allow this evidence to be led? This is another question. The second question I put: if you thought that there should have been a foundation in the pleading to enable you to lead the evidence, then what should you have done is this: when the witness was put into the box, they should have objected, no, this witness cannot go in because there is no pleading. And the tribunal should have said that I am not going to entertain this evidence because there is no foundation of it in the pleading. That did not happen. I tell you, lordship, I personally feel the basic reason for this kind of mistake, it's a grave error, is, my lord, failure to frame issues. Well, how important the framing of issues is under Order 14 of the Code of Civil Procedure, we have come to realize who had been dealing with suits in our younger days. We used to concentrate on the issues only. When we used to analyze the evidence, we used to see how much of this evidence can be fitted under one of each of these issues. Otherwise, my lord, what happens is that a huge gap is left, and this is a glaring example of it.
1 second, Mr. Mitra. Mr. Singh, has Mr. Abhrojit Mitra finished? No. So once he comes, we'll take it up.
My lord, this is, I was showing your lordship this. The point is this: I am not going to tell your lordship that this is the value of this, the weight of evidence which I have led is such that you cannot deny it or dispute it. I say that I have led evidence. Should you have ignored it altogether? That is the question, nothing more. If, my lord, the learned tribunal had looked into the evidence, weighed it, and said, no, I reject it because it is not acceptable,
or even say it's irrelevant.
It is irrelevant. Then I couldn't have come before your lordship and questioned this. The perversity has arisen because of this. My lord, kindly, my lord, in this connection, I drew your lordship's attention to this judgment. Kindly, my lord, take once this judgment, my lord. This paragraph 11, I placed it before your lordship. I just indicate, this is, my lord, the judgment of, my lord, Bharat Coking Coal, which has been referred to and relied upon in 2004-5 Supreme Court cases 109. That paragraph has been quoted. This, my lord, this paragraph has been quoted. My lord, this is reported in, my lord, 2004-5 Supreme Court cases 109. And this is what it says: there are limitations upon the scope of interference in the award passed by an arbitrator. What are the limitations? When the arbitrator has applied his mind, well, this is one. Kindly come to para 11 of this judgment. And this para has been quoted with approval, in, my lord, in the latest judgment which has been placed before your lordship. Para 11. There are limitations upon the scope of interference in awards passed by the arbitrator when an arbitrator has applied his mind to three things: the pleadings. I say they did not apply their mind to the pleadings. The evidence adduced, did not, my lord, apply their mind to the evidence adduced before him, and the terms of the contract. My lord, I submit to your lordship, if they do not, then my lord, the limitations which are there imposed is lifted. And I can urge before your lordship that, look, here is the tribunal who did not look into the pleadings, did not consider it properly, did not look into the evidence, ignored it totally, and the terms of the contract, whatever is there. So, my lord, my submission is this: in the facts of this case, the perversity in this particular award has arisen because the learned arbitrator had first of all relied upon as evidence something which is not the evidence. Namely, my lord, what has been said to be the finding of the CCI and my lord confirmed with the Delhi High Court is not the finding. And secondly, my lord, the evidence which has been led, my lord, in this particular arbitration had been, my lord, erroneously. I respectfully submit to your lordship, erroneously. I am not going to use any harsher terms. It has been erroneously left out. Shouldn't have been left out. Since it has been left out, this entire basis of the award has been vitiated. Well, I will submit to your lordship that this is, and on the basis of this, we have given in the report in our submission. This is what I have placed before lordship from Chrysil. Then, my lord, the care report, exactly the same. Further things have been said here. This is October 2012, and they are saying how, my lord, the sale is increasing, the care rating, and apart from it, well,
2015 যেটা তো আছে 2015 এর ক্ষেত্রেও ইনক্রিজ হয়েছে
well, 2050, your lordship has been pleased to just now ask me 2015. If your lordship kindly comes to
47
page, এটা আমার 47 কোথায় রি
এটাই 47
এটাই 47
লাস্ট প্যারাগ্রাফ দেখুন লাস্ট লাইন
মার্ক করা আছে
লাস্ট প্যারাগ্রাফ লাস্ট লাইন
my lord, kindly come to this is my lord care report at page in the written notes, my lord, this is page 47 na 47 এটা আমার মার্ক করা নেই page 47. This has also been tendered in evidence as an as ER. Kindly see, my lord, the last paragraph of that page. Credit risk assessment, second paragraph. The total income increased by approximately 30% during financial year 14 on account of 25% increase in volume of gas. So gas sold 94.38 mm SCM as against 75.75 mm SCM during financial year 13, and better sales realization on so-and-so SCM as against so-and-so in financial year 2013 refers to the period April 1 to March 31. The realization improved primarily on account of favorable demand-supply scenario, so-and-so, PBLTD. This is profit. দাঁড়াও না ছটফট করছো কেন তো তাড়া আছি জজ সাহেবের তাড়া নেই আমারও তাড়া নেই supply scenario PBLT, profit before interest and lease depreciation and taxes on account of operating income absorbing higher capital costs, so and so turned positive in financial year so and so, doubled since then. During financial 14, the company reported PAT of rupees so and so, leading to a PAT margin of 38.09% as against 38.96 crores and PAT origin 24.63%. So from 23.63 to 38.09. During financial year 2015, your lordship has got the last sentence. The company reported a PAT of 23.87 crores on a total operating income of 58.05 crores as against PAT of 11.97 crores on a total operating income of 41.97 crores during so and so. So there has been a continuous income 13, 14, 15 like that.
Post termination increased হয়েছে
And my lord, this is, my lord, after the termination. Your lordship has been pleased to see. These are all going on increasing. So our contention was, then how could you have suffered loss on the basis of which you are claiming this? This is almost a windfall. I am, my lord, in Bengali we call it, my lord, গাছেরও খাবো তলারও করবো.
No, they would probably say that the profit would have been much higher, but for this loss.
Let them say that. If they had said so, then, my lord, I would have been out. I wouldn't have been able. They did not say this. The point is this evidence should have been at least considered. My lord, kindly come to page 48.
Oh, Mr. Mitra, can we stop today? Because Mr. Abrojit, I couldn't see Mr. Abrojit Mitra. He's right behind you. So
My lord, he had
otherwise
been
you
hiding. He had been hiding deliberately. He had sat behind me. Very well, my lord, we shall.
He'll come back when Monday?
Monday, my lord, I have got some problem.
Acha.
Can it be on Wednesday?
It a key original side.
Either Monday or generally, my lord, Monday or Friday.
Commercial. Monday or Friday. Friday.
Friday will be all right with me, but
Because Wednesday we will first take up non-commercial.
very well.
Monday first commercial, Wednesday first non-commercial, Friday again first commercial.
Yes, but non-commercial is very heavy.
Yes, so therefore it's unlikely that on Wednesday, even if we list it,
Then should it be listed on Friday?
Friday.
Lordship.
My lord, I hope, my lord, Mr. Mitra will continue, my lord. Friday, my lord, I have some, my lord, personal difficulty on Friday, my lord, after 11.
Mr. Banerjee, no
So, my
problem.
lord,
Once Mr. Mitra, even if he concludes, we'll post it on another day.
No, but I can
Very
assure.
well, very well.
But
Very
I
well.
can assure Mr. Banerjee that until he comes back, I shall continue.
So he'll continue until you come back.
No, my lord. No, I'm quite happy, my lord, if he finishes on Friday. Let, my lord.
Lekho. Mr. Jayanta Kumar Mitra, Kamalanet Senior Counsel, representing the appellant, resumes his argument but does not conclude. Paragraph as requested, list this matter once again on Shamne Shukrobar diye dao.
August.
Its position, retaining its position.
I'm so grateful.
Well,
compilation.
1236, item number 9.
But you others want to know whether.
Yes, others can go.
I will go now point-wise. I will show my judgments. The points which I will urge is parties to the MOU. I had shown that Prabhu, because that's the principal point on which I have lost really. Because if Prabhu is not a party, I can't get an injunction against him. Next, I will go into.
Oh, you said no stamp only.
No stamp only.
No stamp.
How far that's significant, and then I will go into the aspect of second MOU abandonment or supersession. Factual apart, legally whether that can at all be justiciable. Then lastly, it is their approbate, reprobate, because in another suit on oath, when they say that and they argue to the court that this second MOU is a void contract, whether they can, in this proceeding, say that has superseded the earlier contract. Then I'll go with limitation. And lastly, of course, that's an entire discretion, scope of interim order in a section 9. My lord, so far as the MOU is, let's start with the parties first. We had given a note, no? Lordship would ask for a note. Or note, list of these. So I had only one. So far as the parties are concerned, that Prabhu is not only is a party to the, is it a party to the agreement? We have just compiled in one chart all the documents which have been signed by the respondent numbers 1 and 2 on behalf of Prabhu in all these, in the records of the court. Like, I will just show my lordship has seen those documents, except one which I had missed out by my junior showed me.
You had cited 2011 1 CHN. That's Justice Banerjee.
Justice Banerjee, yes. Where it was not even named. Leave aside rubber stamp. Not even named. Now that's become the order of the day. Then it was a very revolutionary judgment, but that's become the order of the day. Now the documents, just there are altogether, okay now, there are 11 documents here, 11 sets of documents. First is the MOU. It's been signed by Ram Gopal, the father of respondent numbers 1 and 2, saying that Prabhu is a part of group 1. So that is, I've given the page number of the convenience volume. Second document, page 2, is the annual return of Prabhu, which I had not shown. I don't want to. That is annual return of Prabhu is signed by the respondent numbers 1 and 2, Anuj and Maruti and Anuj. Page 25 of the convenience volume. 18 and 25. Annual return for 31st March 2013. That is the year when it was. Then directors of Prabhu. Page number down. Page number they referenced. Well, we have missed out the proposal of number 3. All 3 are directors of Prabhu as per the same annual return.
15 and 16.
That is pages 15 and 16 of convenience volume. And similarly, number 4, the majority shares are held by Anuj, Maruti, whatever Aditya. Who's the
Aditya was a director.
Was the shareholder also.
Yes,
So, and if you also add Aditya Maheshwari, who was also a part of group 1, but there's no relief claimed against him. He also had shares. That is page 4 of page shareholding. Page 20.
22.
Page 22 is of the convenience volume. All the shareholders
10,100 shares on that table.
of Aditya. All the others.
All the others are there.
22.
Maruti.
Then corporate guarantee for Prabhu is signed by, corporate guarantee given by Prabhu for the loans of PI Minerals. There also Prabhu, it is signed by respondent numbers 1 and 2. Then 13th September 2013, that is the agreement with PI Minerals signed for Prabhu by one of them. Then the SEBI disclosures, pre-sale, post-sale, all signed by respondent number 2 on behalf of Prabhu. Then I had missed out one letter, very important, that is serial number 8. That is the letter at page 92. Very important letter. After the cutoff date, compilation. Page 92. After the cutoff date, one of the respondent number 2 writes, 31st July, the MOUs. So, the originally agreed cutoff date was. Like the second time around, they also wrote in 2017, 92, paragraph 1 as I should have pointed out in my openings before I went to the case laws. Anuj Maheshwari writes 30 on 7th October 2030. Very upset that he hasn't got his money as yet. As per the memorandum of understanding dated 17th March 2030, executed and signed between Group 1, Ram Gopal Maheshwari and Group, and Group 2, Anjani Lakhotia and Group 2 brothers. In terms of the MOU wherein undersigned was also a signatory on behalf of Group 1, Clause 2 and 3 stipulated for exit of members of Group 1 from the management of MBL subject to fulfillment of conditions. Paragraph 2. The terms of the said MOU was not implemented by you as you failed to perform each of the terms involving financial obligation from your side. This is on 7th October. Before that date, we had started paying his brother's wife, Shweta Maheshwari. Kindly see, immediately thereafter, on 11th October, we paid him. Kindly see, page 39 is the chart, and there was no complaint thereafter. And after that, after they got the money, because after we got this letter, 7th October, page 39 on 11th October and 15th October, we paid him his portion. Then afterwards in January, we paid him the rest. So he is reiterating this MOU and complaining against financial obligations was not implemented by you. And this is after 31st of July.
Stores acted upon the shares were transferred and then it is
বলেছি তো সেকেন্ড মেমোরিটা কোথায় ঠিক আছে ওটা ডেট কত হতো
30th October 20.
Now, Lordship, so these are the facts, Lordship. I had summarized them here in this. All the documents, different documents signed by the other respondents on behalf of Prabhu, and even these. Now, judgments, apart from Niranjan Todi, so far as parties are concerned, I had shown Niranjan Todi. Now I'll come to the latest judgments. That is, first I am showing is Ajay Madhusudan. Deya hoyeche na deya hoyni copy diyechilam. ওটা আমি দিয়ে দাও জায়গাটা বার করে দাও First is Ajay Madhusudan.
Para 64, 68, 70 and 8. Match করবো তো? যদি show.
কোথায় লিখেছিলাম ওইখানে কোথায় লিখেছি খুঁজে পাচ্ছি না কেন ওইটা Ajay Madhusudan Patel. এখন রিপোর্ট হয়নি এখন
রিপোর্ট হয়ে গেছে তো রিপোর্ট এটা 2025
my no scope to trial code. It's 2025 to SCC 147 paragraphs 64 onwards, page 177. This will save my lords the trouble of being placed Cox and Kings also, because they're extensively quoted from Cox and Kings. আগে মিলবে তো এর সঙ্গে না 1 সেকেন্ড মিলবে তো তখন তো এসএসসি অনলাইন
অনলাইনে কপি শুরু হচ্ছে কি প্যারা 73 থেকে
হ্যাঁ প্যারা 73 লর্ডশিপ কাইন্ডলি কাম টু প্যারাগ্রাফ 73 না তোমার যে বই 73
Not 64.
4 was in SCC.
No, it was in the SCC online printer.
কোন জায়গায় দেখাবো বলো কোন জায়গায় para quote করেছে then 75 pivotal issue এর nonsense.
The recent constitution bench specifically dealt with the question of impleading a non-signatory as a party. Para 73, page 182. Impleading a non-signatory as a party in the arbitration proceeding and the corresponding scope of inquiry at the referral stage. It was held herein that Section 16 is an inclusive provision which comprehends all preliminary issues touching upon the jurisdiction of the arbitral tribunal, and the issue of determining parties to an arbitration agreement goes to the very root of the jurisdictional competence of the arbitral tribunal. And then Cox and Kings is quoted.
Para 81. Therefore, on the pivotal.
Then now you will see 183, just above paragraph 75.
75, then you show it.
Just the last 3 lines above para 75. At the referral stage, the referral court should leave it for the arbitral tribunal to decide whether non-signatory is bound by the arbitration agreement. Now, para 75 says the same thing.
81.
And to make it short, paragraph 77, page 185. Whether on a prima facie view, the SRG group, being a non-signatory to the FAA, can be referred to arbitration. It is well settled that an arbitration agreement, in order to qualify as a valid agreement, has to satisfy the requirements of Section 7, along with principles of law under the Indian Contract Act, having regard to the submissions of both the respondent group, JRS and SRG. It can be said that they have raised manifold objections to the present petition. However, none of these objections question or deny the existence of the arbitration agreement under which the arbitration clause has been invoked. In fact, JRS has no objection to resolve the dispute with the AMP group by arbitration. Their primary objection is only that the SRG group cannot be a party of the arbitration agreement. Therefore, the requirement of prima facie existence of an arbitration agreement as stated in Section 11 is satisfied. However, the core issue that falls for our consideration is whether SRG group, being a non-signatory of the FAA, can also be referred. This court with Cox and Kings held that the definition of parties under 2(1)H read with Section 7 of the Act includes both the signatory as well as non-signatory parties. Persons or entities who have not formally signed the arbitration agreement or the underlying contract containing the arbitration agreement may also intend to be bound by the terms of the agreement. This is what I'm stressing on. Further, the requirement of a written agreement under Section 7 of the 96 Act does not exclude the possibility of binding non-signatory parties if there is a defined legal relationship between the signatory and non-signatory parties. Therefore, the issue as to who is a party to an arbitration agreement is primarily an issue of consent. Actions or conduct could be an indicator of the consent of a party to be bound by the arbitration. This aspect is also evident from a reading of Section 7(4)(b), which emphasizes on the manifestation of the consent of parties or entitles or entities through actions of exchanging documents. The relevant observations made in Cox and Kings are extracted below. I should italics portion. First, arbitration. Reading Section 7 of the Act in view of the above discussion gives rise to the following conclusions. First, arbitration agreements arise out of a legal relationship. Or fourth, that is just after placitum third and fourth. That is placitum A at page 186. Third, it is not necessary for the parties or entities to be signatories to the arbitration agreement to be bound by it. Fourth, in case of non-signatory parties, the important determination for the courts is whether the persons or entities intended or consented to be bound by the arbitration agreement or the underlying contract containing the arbitration agreement through their acts or conduct. Fifth, the requirement of a written arbitration agreement has to be adhered to strictly, but the form in which such agreement is recorded is irrelevant. Sixth, the requirement of a written arbitration agreement does not exclude the possibility of binding non-signatory parties if there is a defined legal relationship between signatory and non-signatory parties. And seventh, Once the validity of an arbitration agreement is established, the court or tribunal can determine the issue of which parties are bound by such agreement. And para 81 is really the conclusion, page 187, para 81. The fact that a non-signatory did not put pen to paper may be an indicator of its intention to not assume any rights, responsibilities, or obligations under law. However, the courts and tribunals should not adopt a conservative approach to exclude all persons or entities who intended to be bound by the underlying contract containing the arbitration agreement through their conduct and their relationship with the signatory parties. The mutual intent of the parties, relationship of a non-signatory with the signatory, commonality of the subject matter, composite nature of transaction, and performance of the contract are all factors. I am not formally citing, but I am formally citing Cox and King, which I am not placing because that's relevant parts have been extracted here. So that's a full bench judgment. May I just hand up these judgments? That is Cox and Kings is 2024 4S, page 1. I will not place. I'll come to the later judgment after this. Is the Shapurji. That was a Muslim name. Shapurji. The Muslim name. Aslam. তার আগে সাপুজি কে দেবো? সাপুজি তার আগে আসলাম বলছো লিমিটেশন গুলো তো কোন বিকেন্সে তুমি ওকে সাপুজি আগে দাও সাপুজি the latest judgment here more well settled the law is the thicker gets the judgment.
That's also Justice Pardiwala, no?
Yes. Yes.
কোন জায়গায় বলতো
112 112 আরে 13 112
SCC not yet been reported. Report হয়েছে এখন
মনে হয় SCC অনলাইন
SCC বুকে রিপোর্ট হয়
same as just ওকে হলে রিপোর্ট হলে
can come out anytime. This is may have been, I don't know, the latest book. Now loose journals don't come, it is after binding it comes. Page number 98, SCC printout page number 9. এটাকে দিয়ে দাও একটা কপি আর কাগজ বাড়িও না
2025 C 101
112. Paragraph 112. However, with the advent of Cox and Kings, the legal foundation for the application. Page 98 of the SCC printer. However, with the advent of Cox and Kings, the legal foundation for the application of the group of companies doctrine or any analogous principles designed to determine mutual consent was clarified to exist in the definition of party under section 2(1)h, read with the meaning of arbitration agreement under section 7. Unlike sections 8 and 45 of the 1996 Act, the provisions of section 2(1)h and 7 are not confined in their applicability to only judicial forums or courts, and rather extend equally to both courts and arbitral tribunals, as these provisions from the bedrock of the framework of arbitration under the 1996 Act form the bedrock. The logical sequitur of this is that arbitral tribunals too are vested with the requisite authority to engage with and apply principles such as the group of companies doctrine when determining whether a non-signatory they will be bound by an arbitration. It's well within the jurisdiction of the arbitral tribunal to decide the issue of joinder and non-joinder of parties, and to assess the applicability of the group of companies doctrine. Neither in Cox and Kings nor in Ajay Madhusudan, this court has said that it is only the reference court that are empowered to determine whether a non-signatory shall be deferred to arbitration. The law has developed over a period of time is that both courts and tribunals are fully empowered to decide issues of impediment as a non-signatory, and arbitral tribunals have been held to be preferred forum for the adjudication of the same. In the case of Ajay Madhusudan, this court, placing reliance on Cox and Kings, has expressly held that 16 is an inclusive provision which comprehends all preliminary issues touching upon the jurisdiction. And the issue of determining the parties to an arbitration goes to the very root of the judicial competence. The case of Ajay Madhusudan also recognizes that the legal relationship between the signatory and non-signatory assumes significance in determining whether the non-signatory can be taken to be bound by the arbitration. This court also issued a caveat that the courts and tribunals should not adopt a conservative approach to exclude all persons or entities who are otherwise bound by the underlying contract containing the arbitration agreement through their conduct and their relationship with the signatory parties. The mutual intent of the parties, relationship of a non-signatory with a signatory, commonality of the subject matter, composite, we pass each and every one of these tests. Composite nature of the transaction and performance of the contract are all factors. Firstly, we are named party. Secondly, nature of transaction, then relationship, non-signatory, signatory, intent of the parties, agreement clauses. So every score I qualify. So if it has to go to arbitration, then the arbitrator should be deciding, and for the time being, Lordship will prima facie proceed that they are also a party. Okay. A visa interview next Wednesday morning.
Then next Friday same time? এই নেই হবে না? অন্য কোনো দিন? You're not there on Wednesday.
Only Wednesday.
বুধবার বাদ দিয়ে।
Wednesday second half I am there. First half only.
Wednesday second half you are there.
I am also in some difficulty on Wednesday.
কি হবে?
তাহলে আমার এই ভিসা আছে।
তো অন্য কোনো দিন দেখো। অনেক দেরি হয়ে যাচ্ছে।
Next Monday, Tuesday.
Monday, 11th August.
কখন? How long it will take?
I should be 1 hour. I should finish. 3:30. Lordship keeps it any day.
3:30. All slots are. We can give you Monday week.
Monday week morning we have a fixed matter. Second half I have.
Monday week কখন দেবে বলছো? তাহলে তো অন্য কিছু হবে না। দেখো আর উল্টাও পাতা। পিছিয়ে দিয়ে লাভ নেই, অত পিছিয়ে সব না দেখি তোমার ডায়েরি দেখি। আচ্ছা 5th August ঠিক আছে 5th August টিউজডে করো তুমি 12:30 try to wrap it up in 45 minutes. Mr. Abhijit Mitra, learned senior counsel representing the appellant, resumes his argument but does not conclude. Paragraph. Lists the matter once again on August 5, 2025, marked 12:30 p.m.
I have a
Hey, now, one second, Mr. Banerjee. Now, to me,
item number 4 today. I have
which list?
today's commercial
OCD commercial, yes. Yes.
can be fixed on next Friday because Monday and Tuesday I'm in some difficulty. I will be out of station. I've informed my other side, he is also present.
এই শোনো আজকে যেটা ওসিডি 4 নম্বর নেক্সট ফ্রাইডে করে দাও তিনটে
3:30.
Mr. Mitra, your Anandulok will take up at 3 o'clock.
Very well.
My lord, one application for review. My lord, both my lords have passed this order.
What do you want?
Because it has to, my lord, next date, my lord, when my lord will be sitting. Yes. And my lord, another in the, my lord, this honorable division bench has passed that original order. Against that, my lord, I filed a review application. So naturally, my lord has to, my lords.
Please give the number.
Yes, I have, and I have served a notice.
Call,
And my lord, only one, my lord. Item number 14, my lord, only 2 days time. Item number 14.
Today's list.
Yes.
Yes. What
My lord,
do you want?
Only not today, my lord.
Only?
Only not today. That means next.
You are for whom?
I am for the respondent.
Petitioner is not here. Ex parte, we'll
No,
make
no.
it not today. Dakun, let's go.
To mention, compelled to mention for inclusion, there is a contempt application.
This bench.
This is the third time I am mentioning.
Why?
Kindly seize the order. I'm so sorry. I just have one copy.
No, it will be listed. Shunun. Keno dichche na liste?
Just to come, my lord.
Diye din.
May I be permitted to mention, my lord, a relaxation, my lord, assigned matter.
Relaxation of conditions of bail. Assigned matter. Tao te baba. What is the देखी
নামটা কি?
ठीक है
So I am for the petitioner. Kindly consider order dated
Item number
25th.
1, my lord, I beg to appear on behalf of the contender. There's a direction for personal appearance. On the last occasion, I took time, my lord, because he was in, my lord, North Bengal for, my lord, the municipal affairs department. My lord, after returning, my lord, immediately admitted in a hospital. I brought all the paper and municipal secretary is here. My lord, he's the municipal secretary of Mohesala municipality.
What can be done then? We'll have to adjourn.
All papers are there.
We'll adjourn for a fortnight.
Possibly, my lord, he requires a surgery. My lord, 15 days, lordship, kindly keep it in mind, my lord, he requires surgery.
We'll give you 3 weeks.
Lordship, only one thing, Lordship, may I? Lordship, this is absolutely an unavoidable circumstances. The alleged contemptor could not come. But Lordship, I'm questioning myself, Lordship, what prevented them from considering complying your Lordship's order?
Last page, my lord. On 30th July, my lord,
So what, Lordship, even Lordship, they kindly consider, as per your Lordship's request, I have
Mr. Mukherjee,
all these
Mr. Mukherjee, we are trying to help your client as much as possible. This gentleman is in hospital requiring surgery. Please do not proceed any further at the moment. Come back after 3 weeks. Mr. Chakraborty, read order dated July 25, 2025, paragraph. Mr. Chakraborty, learned advocate appearing for the alleged contempt laws, produces medical documents and submits that the alleged contempt number 1, immediately upon his return from North Bengal, has been admitted to hospital. Stop. He would require surgery. Stop. Mr. Chakraborty requests that this matter be listed after 15 days. Paragraph, list this matter after 15 days, whenever this bench is again available. Next, Daku.
It is ours. My lord, Mr. Basu Malik is appearing for respondent contempt number 1 and 2.
Yes.
He's engaged in a continuing matter in courtroom.
Very well. Let us hear the petitioner. There are other parties also. Inform him. Mr. Dottu is appearing for whom?
I don't know 3.
Oh, 3. Mr. Odhikari, my brother has done all the reading. He will conduct the case.
I'm really grateful that His Lordship has given me this opportunity to interact with you.
We are all grateful.
Yes. He is all praise for you. His Lordship is all praise for you. Because you are very
We are all grateful
good
to your
auditor
topics, my lord.
and always to the point. How long you are practicing here?
My lord,
45 years
45 years.
or 50 years?
Since 1979, actually, I am practicing Calcutta High
1979.
Court, 1979.
Take the microphone.
46 years. 46.
My lord. And my lord, that
Only 4 years
only
left.
here also in the Supreme Court. I am the member of the Supreme Court Bar Association first. In the year 1980, my lord, I was under Govindo Mukhoti. And Govindo Mukhoti is senior advocate. My lord, I was also, my lord, known to sirs, my lord's father, my lord, that the very enthusiastic, and my lord, that encouraged me in those days. My lord, we are grateful. That means that we are getting the same tradition. And my lord, that I
You have taken
became the
license,
member
you
of
have
the Supreme Court Bar Association first, thereafter in Calcutta.
You have 75 license holder or something.
My lord, 79s.
79.
But mostly you used to appear in Supreme Court, all
Yes,
the constitutional cases,
mainly in
in
constitutional
important
cases,
matters.
even in important matters, even with Indra Jai Singh, that very particular matter of 2017. That means that the why the means eradication, total eradication of the means
1979.
the senior gown. That means there was my, and it was
So your registration number is of the year 1979.
1917, there were 80, my lord. Some, my lord, that for some days I had been means as the Ranaghat College's lecturer.
Oh,
my lord, I left that job here and I thought my grandfather, Janaki Vallabh Bhattacharya, my lord, that he was the Sanskrit College's, my lord, principal. Then, my lord, he encouraged me. I am from Bhatpara, my lord.
So what is
Mr.
the allegation?
Mr. Just before we take up the matter, someday we would be delighted to see if you are arguing before the World Court, International Court of Justice.
Because Horish Salve is there,
Oh.
my best friend. Horish Salve is acquiring that place. Oh, Horish Salve.
Calcutta is your best friend.
Horish, my lord.
No one from Calcutta is your best friend.
My lord, all are, my lord. Even I like Calcuttans because that I like. Mr. Bhattacharya off and on meets me in Supreme Court, and I am very delighted with his association in Supreme Court. He encourages me to.
So what is the allegation? What is the allegation?
My lord,
against-
the allegation is, my lord, it is your lordship's discretion whether, my lord, that there is contempt or not. My lord, they are still flouting the Honorable Court's order.
Honorable Court, Chief Justice's order.
My lord, your lord, my lord. Now we have to say, my lord, that this Honorable Court's order, my lord. My lord, if even today, my lord, they are not complying with this order.
So
My
what is
lord,
the allegation against
the
him?
allegation against, my lord, that if your lordship will kindly see, my lord, there was, my lord, AO and AR, and my lord, that in AO, what they have stated, I have already replied in my AR. My lord, your lordship's sanctity and wisdom, my lord, permitted, my lord, both the sides, so
What
that
I
there
have
will
found,
be
what I have found that there was a stay order on 17/9/2019.
My
Is
lord.
it correct?
My lord, yes.
17/9/2019, there was a stay order
My
drafted by the then Honorable Chief Justice and my brother.
My lord.
The stay of all further proceeding.
My lord.
Or there is a permanent stay order or
My lord, even if it is not permanent stay order, but my lord, that the letter and spirit of that order is to be followed, my lord, strictly in accordance with law. Because, my lord, this order has never been, my lord, challenged either in the superior forum, nor they have ever tried at least to modify or alter the order.
so stay order was on 17/9/2019.
My lord.
And when warrant of arrest was issued?
My lord, kindly, my lord, if my lord, if it will be seen in this way, my lord, your lordship will kindly see one after the other, my lord. What I am placing before your lordship will kindly see the particular, my lord, my lord, my reply is to be seen first, my lord, that the contender number one.
I have some questions to you. When warrant of arrest was issued?
The warrant of arrest
was issued
order
on 21/6/2022.
My lord.
Please,
my lord,
look
what
it
they
down.
have done, my lord,
Yes,
what
yes.
they have done, my lord, if first of all, my lord, the contender number one, kindly have a look to the affidavit in reply. My lord, kindly. My lord, there we have stated, my lord, clearly. They have already filed their AO, and my lord, it is with the record. And my lord, in paragraph 3 of my reply A, we have stated it is very interesting that the contender number one, nowhere in the entire affidavit sworn by him before this honorable court, stated that he had no knowledge of the solemn order of 17/9/2019 or the said solemn order dated 17/9/2019 was beyond his knowledge when he passed orders dated 19/9/2019. Any man, therefore, it was never denied clearly. If your lordship will kindly take pain to go through their affidavit in opposition.
No,
My lord,
I want to cut short the
Therefore,
matter.
my lord.
I want to cut short the matters. There are so many matters before us that when warrant of arrest was issued on 21/6/2022, is it correct or not?
My lord, it is correct.
21/6. And when the petitioners were arrested?
My lord, the petitioner was arrested on the basis of it.
25/6/2022.
My lord, your lordship will kindly see.
25/6/2022.
Yes. Your lordship will say, my lord, first of all, if your lordship will kindly see the R5 at page 43.
Yes.
Of the contender number ones, my lord, that is the reply which I have given, my lord.
You were arrested on 20.
There, my lord, at page 43, it has started in response to your RTI dated 6/11/2019. Like to inform that a report of Pusi Daspur with DR such and such 19/12/99 copy of warrant. Therefore, it will be very much clear. At page 43.
Page 43.
Page 43 R5. My lord, it will clear everything. Copy of warrant and court's order are attached herewith for your information.
25 from
My
the record, it appears that 25/6/2022
My lord.
petitioners were arrested.
There it is stated, it appears to the above at page 45, it is clear, my lord. To the deputy superintendent of police, your lordship has got memo number such and such.
And
here it is, my lord, in apropos to the above, I beg to submit that a warrant of arrest in the name of Rabindranath Phadikar, son of such and such, have been issued from the court of Learned Additional Session and District Judge Ghatal.
When?
My lord, on 19/9/2019. Therefore, on 17/9/2019, the honorable courts were, means rather the order was there. Immediately, he got furiated. And my lord, he did not care for any law of the land, did not care for, means what I have been told.
Now, have you submitted the copy of the stay order? Please show us.
Yes.
Where?
Your lordship will kindly see,
You have said
my lord,
that
whatever may be, my lord, we are not going any controversy, whether I have submitted or not, whether they are denying, they have nowhere denied.
Please listen to me.
They have nowhere denied.
Submitted a copy of the said order before his honor by hand. By hand means what does it mean? By hand?
No, it is what submitted.
Your
petition from your lordship is getting at page 44.
Paragraph number 3. Now, your petition.
My lord, my petition, paragraph 3 means in all ways we have given, it is there. Paragraph 3, we have stated, any man of ordinary prudence under such circumstances would count.
Warrant of arrest was issued on 21/6/2022. At that time, whether there was any stay order or not, whether there was any stay order.
Yes, on 17 there was a stay order by the Honorable High Court, by your lordships.
17/9/2019. Stay
and
order
in
was
pages
passed.
of all the persons.
Please listen to my question.
My lord.
On 17/9/2019, the
affidavit to compliance within inverted comma দেবে file on behalf of the alleged contemnor in court today be kept with the records. Paragraph, the petitioner will be at liberty, petitioners will be at liberty to file their response to the said affidavit before the next date. Paragraph lists the matter once again on August 18. 22.
By that time, we will come.
You please go and inspect.
But we have, my lord, we have the
No.
photographs also.
They are saying they are going to demolish over the next 5 days.
Yes, madam.
Yes, I have the report with me.
Chalo now. For the next matter.
You can have a copy also.
Yeah.
And the copy of the report also served to them. They're very serious about it. Item number 3.
नहीं चलो पासो बस चलो
I appear for the alleged contempt for this.
7.
I am for this contempt number 3 and
Oh yes, that one.
That in terms of a losses order, because initially the Honorable Single Bench my lord passed an order for.
No, we remember nobody is there for the petitioner, Mr. Ghosh. Not today, because 3 o'clock we'll take up original side. Not today. Dako.
Item number 8.
We are filing an affidavit of full compliance of my lord's order. Your lordship was pleased to grant us, Lord, some time to complete the selection process.
Oh, that one. Consider it, take it, we are not disposing of. Give a copy. An affidavit described as affidavit of compliance.
Yes, Lord, the selection list and has already been published.
Filed on behalf of the alleged contemnors, be kept with the records. Stop. A copy of the said affidavit has been made over to learned advocate for the petitioners, who seeks a little time to consider the same and come back. Stop. The petitioners will be at liberty to file their response to the said affidavit before the next date. Paragraph lists the matter. এই বেঞ্চটা আবার কবে আছে 22-এর আগে না 22-এর আগে নেই আর 22nd August 22.
Deeply.
Any fresh matter for the first time? নেই তাহলে original side দেখো
10 is for the first time.
Which one? 10? তাহলে 10টা দাও দেখো 10টা.
I'm appearing for the alleged contempt.
How are you appearing?
An order has been complied with.
How are you appearing? Have you served on him? Then how are you appearing?
Going through the list, my lord, I have come to know contempt is against me.
Let me serve
Very
and
well.
come back. Let the contemnor assign him so that he can appear.
না ভাই যন্ত্র আছে
এখন দরকার নেই ওরা কখন সার্ভিস করবে করুক করে সার্ভিস করুক
Which is that order?
Page 16 is the operating part.
Not yet disposed of the representation. Isho, this contempt application has been taken out, alleging willful violation of a judgment and order dated September 25, 2023, whereby we had disposed of MAT 1672 of 2023 along with the connected application. Stop. The operative portion of the said order reads as follows, page 16 থেকে 16 and 17 থেকে bracketed portion. Paragraph, learned advocate for the petitioner says that till date his representation has not been disposed of.
Constitutional steps has also not been done. Second page.
No, unless that is first disposed of naturally. And therefore, the consequential steps have not been taken. Paragraph, let a copy of the contempt petition be served. How many contemners? Let একটাই. On the alleged contemnor, and affidavit of service be filed in court on the next date. Paragraph, list the matter on August 22.
Lordship, item number 14, Lordship.
14.
Lordship, kindly see the last order, Lordship.
First time?
No, Lordship.
Then what?
Lordship, in the month of February, Lordship directed to pay 10 lakhs, Lordship.
Yes.
Till now, Lordship, after 6 months, they have not paid, Lordship. I went to several
Very well,
times,
come back next day.
Lordship.
Original side, original side. It
Original side better. In your application, item number 1 and 2.
Yeah. Yes, Mr. Reddy.
তুমি যাবে না ওখানে করলো না জিষ্ণু এত চেঁচামেচি করে তবে কি করলো কালি ফিক্স হলো 3:15 হবে আজকে শেষ করে দিই ও
Wind up, Mr. Banerjee. Now we frank to you, we are getting a little impatient.
I'll finish up in 2 days. I could gauge that, Lord. Between me and a little bit of informal banter between me and Mr. That's because Mr. Chaudhary and Mr. Mitro have a duel at 3:15.
Again, their last attempt at stalling the special board meeting. Great agitation.
We were all there in
for a special board meeting, so now they are trying to stall it.
We were before Justice Krishna Rao's court where the matter has now been assigned.
Mr. Chaudhary.
Mr. Jishnu Chaudhary.
Oh yes.
Versus Mr. Abhrojit Mitro, with Mr. Mitro not having a mic and Mr. Jishnu Chaudhary making full use of the mic.
No, but he doesn't need a mic. He's on mic.
That by not getting angry makes many people more angry.
The more Mr. Chaudhary would fume, the wider would be Mr. Mitro's smile. Well, just the last part of the order. I was placing, Lord, the last part of the impugned order. If your Lordship recalls the word contagious that came up.
Yes, yes.
May I just very quickly start from the bottom of page 4 again? I'll just brisk it today. Memo appeal দিয়ে দিন ওখান থেকে Lordship আগের দিন দেখছিলাম From the submissions made on behalf of the parties, it appears that there's a dispute raised with regard to ownership of the 700 square meters of vacant land. Petitioners have not been able to produce documents or title deeds to show that the aforesaid 700 square meters were at all sold to the petitioners or were included in the schedule of the deed of conveyance of the petitioners. Prima facie, it appears that the 700 square meters was separate and left out from the portion of the land sold to the petitioners. Petitioners rely upon an affidavit affirmed by the Kolkata Municipal Corporation and earlier writ petition in the year 2003 to show that the vacant portion was shown in the sanction plan pursuant to which construction was raised by the petitioners. The court fails to appreciate as to how the portion which was never sold to a party could be shown as the vacant land for permitting sanction for raising construction thereon. An owner cannot lay claim over the contiguous land in the absence of a valid title deed. Till the land is legally sold in favor of the purchaser, the same cannot be treated as the property of the purchaser for obtaining sanction for raising construction over the property which was sold. The owner of the land who retained the 700 square meters later on sold the same in favor of the private respondents. Kolkata Municipal Corporation mutated the land in favor of the private respondents and allotted separate SSC number and thereafter sanction plan for raising construction thereon. Till the petitioners are able to obtain any order from the competent court declaring their right in respect of the said 700 square meters of land, it will not be proper to restrain the private respondents from raising construction thereon on the basis of a plan sanctioned by the Kolkata Municipal Corporation. It will also be highly improper to direct the corporation to invoke the provisions of section 397 of the KMC Act 1980, as the facts of this case does not warrant the same. The petitioners have not been able to make out a case that there has been either been fraud or misrepresentation at the instance of the private respondents at the time of obtaining sanction for raising construction over the 700 square meters. The private respondents, however, cannot and ought not to disturb the essential services which the petitioners are enjoying for years together and which are running underneath the land where the construction is supposed to be made. Learned counsel appearing for the private respondents have made oral undertaking before the court that the construction will be made in such a manner that the essential services of the petitioners will not be disturbed. Private respondents are restrained from making any construction that will disturb or obstruct the essential services enjoyed by the petitioners underneath the presently vacant 700 square meters of land till the same are shifted in accordance with law. Private respondents will be at liberty to seek shifting of the existing service connections of the petitioners by making appropriate application before the Kolkata Municipal Corporation. In view of the above, the court refrains from exercising jurisdiction. Writ petition fails. Lord, as I had pointed out on the earlier occasion, I will not be repeating those submissions. My humble submission was that the fact that this 700 square meters is part of the earlier plan or the original plan is not disputed. No one is disputing this. Corporation, the best body to say this, has in as many as 3 affidavits said that this 700 square meters was used for car parking. Private respondents themselves, the director of the private respondents, my lord, who was at that point of time who had filed an affidavit on behalf of Nilambar, there in that affidavit had said that that 700 square meters is used for the purpose of car parking. So this is not in dispute at all. In a writ court, we are hardly concerned with title. Even an absence or prima facie absence of title, as the Honorable Single Judge has found, would not denude the present petitioners with the right to have their representation considered. Because as I have shown you, Lordships, my lord, the representation essentially invokes the jurisdiction of the municipal commissioner to look into the sanction which he has granted, which is within and also slightly beyond 397. Being an authority granting a sanction, he has an authority, he has the right to undo the sanction if he finds that it has been granted illegally. That right comes to him, my lord, from the General Clauses Act section 10. That need not come, my lord, by way of a specific right in the statute. Here, there is additionally a specific provision of the statute, that's section 397, which has been invoked. We are persons in possession of the building in question, and therefore we have the locus to point out to him that the 700 square meters being trapped in our plan, it could not have been made the subject matter of a separate sanction. This is the limited point on which we went to the municipal commissioner. For arriving at such finding, the municipal commissioner is not required to look into the aspect of title at all. What the municipal commissioner would have to look into is whether there was a sanction granted in terms of which that 700 square meters was trapped. And if so, if it was trapped in the earlier plan, whether that 700 could subsequently be set apart for a separate site in front of, my lord, my building. That's the limited thing under the statute which the commissioner would look into. Even if it doesn't come within the 4 corners of 397, as in no fraud or misrepresentation has been made by the person applying for sanction, it would still be vulnerable. Such a sanction would still be vulnerable, and the municipal commissioner would be in a position to see if there's any violation of law, he would take it back. Lord, these were, Lord, the submissions which we had made before the learned single judge. The entire reasoning whereby, my lord, our writ petition has been rejected and our prayers spurned on the basis of the prima facie finding that there is no title over the 700 square meters is therefore, in my respectful submission, legally perverse in the present facts and circumstances of the case. There's another thing, Lord, in my writ petition, in our writ petition, where we had sought cancellation of the plan, there is, my lord, a liberty given to the private respondents to seek shifting of the existing service connections from the 700 square meters to somewhere else. This is a liberty which is granted to the private respondents in my writ, my lord, which could not have been granted. And while saying that the private respondents are restrained from making any construction that will disturb or obstruct the essential services, on the one hand, giving a final order of, my lord, restraint on the private respondents in a writ petition, thereafter, my lord, connecting that with the next paragraph where it is said that they will be at liberty to seek shifting, which that means essentially the very plinth, one of the plinths of our challenge has been on facts sought to be negated by an order passed in a writ petition filed by us. One of the plinths of our challenge was that 700 square meters served both on surface and underneath the surface. On the surface, it was serving as a car parking space where the corporation, my lord, has affirmed it thrice in affidavits. Just below the surface, my lord, there were drainage connections, etc., which were present at all material points of time. Water lines were there at all material points of time, which are still there. The deep tube well was also there. The learned judge in my rescue submission exceeded the jurisdiction of her ladyship by permitting the private respondents to shift it from there and making a final order, my lord, of perpetual of a kind of a temporary injunction. A final order, but actually of a temporary injunction, restraining the private respondents from erecting any structure until they shift out the thing from the soil. This was absolutely, my lord, in my rescue submission, my lord, beyond the jurisdiction of the Honorable Single Judge, even in the facts of the present matter, in our writ petition. No such prayer had been made in any writ petition filed, my lord, by the private respondents, or no such issue had cropped up regarding removal of services. Therefore, my lord, in my rescue submission, the only prayer, my lord, that we are seeking for your lordship here is that without expressing any opinion on the merits of the municipal commissioner's consideration, surely a case has been made out in which there is enough materials for the matter to be sent, my lord, to the authority for an inquiry. We are not seeking a mandamus directing him to cancel. We can't, because ultimately it will be the municipal commissioner who will have to look into it. We are also not seeking, my lord, any observations from the Honorable Writ Court when the matter is being sent on remand, my lord, sent to the authority. The remit being to exercise his jurisdiction as a plan sanctioning authority on two counts. Number one, the count of section 397. Number two, over and above that, the count of being an authority, passing an administrative order, taking an administrative action, which is found to be dehors the statute. If he comes to the conclusion that these two provisions of the act are not violated, then he'll have to inform those conclusions with reasons, and then he'll be at liberty, my lord, to reject our representation. The fact that prima facie we don't have any title really does not matter here, because we are persons in occupation of the same single building in which, my lord, the original plan was sanctioned, acted upon by all parties. My lord, this is, my lord, my reciprocal submission. We had flagged our representations. I will not waste your lordship's time by placing it. That was, my lord, at page 363, my lord, of my lord's brief, my lord, volume 2. That is our, my lord, representation. My lords will exactly see that whatever I have submitted here in terms of the merits are all present. Go through, na?
16th November 21.
Yes, my lord. 16 November 2021. We are seeking revocation. This is the covering letter. The actual letter, my lord, is 14th of
Look at
January.
365, yes, 14 January.
14th of January 2021. Very quickly, my lord, brisking through it, my lord. My lords will find that these submissions are made. Please come to paragraph 8. This portion is trapped in a particular...
That is the representation.
Yes, that's the representation.
365.
Yes.
363 is a follow-up letter.
Is a follow-up letter annexing, Lord, the representation. All we are submitting is that, Lord, in terms of Lord, hundreds of judgments that are made by this honorable court, I am not suggesting that it should be sent blindfolded, but here surely there's a case of a prima facie violation of a statutory right made out. Whether that is enough for the municipal commissioner to revoke the sanction is for the commissioner to consider. The court will ordinarily not usurp the jurisdiction of the commissioner. That was also not a prayer here. But to say that because we've been unable to prove up to now that we have title over the land in question, and therefore we will not be permitted to agitate against a violation of a statutory provision which has an adverse civil consequence on us, this perhaps, my lord, in my discourse submission, may not be the correct interpretation of law. Lord, these are my submissions on this. We had placed our judgments, my lord, on the previous occasion. There's one judgment which they've all had been placed, my lord.
এইটা ব্যানার্জির প্রোগ্রামটা খুলে প্লেস করে দিন।
My lord, please come to my lord 2024 SCC online Calcutta 2528, division bench judgment of this honorable court. The earlier ones I have placed, my lord, I'll not be repeating myself.
না মেইনটা
in respect of additional sanction ঠিক বেশি additional construction provision দিয়েছিল সেটা ওনারকে নোটিশ হয়ে ওনার বললো যে এটা কি করে আমার কনসেপ্ট disputed
Again, the notice question of
হ্যাঁ
facts.
না ওখানে কনভিশন ছিল কিন্তু এখানেও তো স্যার আমার তো এখানে নো ডিসপিউটেড কোয়েশ্চেন হচ্ছে 100 স্কয়ার মিটারটা হ্যাজ বিন ইউজড ডিসপিউটেড কোয়েশ্চেন হবে এই লজিকটাকে এই জাজমেন্টটা আপনি বার করে তো আগেই সাপোর্ট করেছিল
Yes, Mr. Banerjee.
Here on slide, on not entirely similar facts, but then, my lord, the question had come up that in the event it is seen that there is interference, my lord, or violation of any statutory provisions by the plan in question, then, my lord, a direction, my lord, for the cancellation of the plan would not be unwarranted. Appeal carried by one of the parties saying that disputed question of title is involved was spurned by an honorable division bench, where my lord Justice Banerjee was also pleased to make, my lord, and a separate concurring order, wherein my lord has been pleased, my lord, to more or less say that the order under appeal should not be interfered with, because that had tried to set right a violation of the provisions of the statute that had taken place, even without going into the question of title. This one, my lord, would broadly be on the question of whether a sanction plan of this nature can at all be sustained with the violation of against the violation of statutory rules. Otherwise, not the earlier ones are more trite. They are on the point.
So only one judicial decisions we have cited.
No, there are couple, four more we had cited earlier.
So please cite, give me the citation.
Well, at this time of rehearing.
Yes. That's দেখুন তো আরো judgment
বলছে আগে 3-4টে দেখিয়েছে।
Give me the citations.
দুই নম্বর চাইছে 617
নিয়ে নাও।
এটা খালি বলবেন না এইটা 2016 এসএসসি অনলাইন ক্যালকাটা এইটা রিপোর্টেড ভার্সনটা দিয়েছিল আর এটাও রিপোর্টেড ভার্সনটা দিয়েছিল। এটা যখন ফাইল করা হয়েছিল তখন রিপোর্টেড হয়নি। স্যার মনে করেন এই বেঞ্চেরই জাজমেন্ট।
Judicial judgment.
ম্যাট দেখাতে চাইছেন না, আর কিছু হয়ে গেছে দেখানো। উনি জাজমেন্ট দিয়েছিলেন কিছু বলছেন আগে, এটাই দাও। আশ্চর্য।
হ্যাঁ হ্যাঁ, নির্মল ছিল দিয়েছে একদম পুরো। হ্যাঁ
Milord, I had cited Milord 2016 SCC Online Calcutta 1972.
That was
আরো আছে।
Then Milord 2021 SCC Online Calcutta 2145. 2023 SCC Online Calcutta 4070. And Milord this Deval.
আমি একটা কপি দিয়ে দেবো স্যার পরের দিনকে।
Would you want to file a short written note after hearing Mr. Mitru? Or no, come back on the, you know what Mr. Mitru will argue. So you won't have sufficient time perhaps to, yes. Next day, which means 22nd August, and again 3 p.m. It is understood, original set will be taken up at 3 p.m. দেখো, হ্যাঁ 8 তারিখ আছে এই বেঞ্চ। না, আমার তো অন্য ভাঙা বেঞ্চও আছে, সেগুলো তো করতে হবে
ভালো হয়
নাকি? Mr. Banerjee, Commander Senior Counsel representing the appellants in MAT 617 of 2023 concludes his opening submission. Paragraph lists this matter once again on August 22, 2025, when Mr. Mitru, learned Senior Counsel for the
Monday he is not here, though Mr. Mukherjee. Let's finish.
counsel for the respondent number 6 will make his submission.
Here 8 and 9.
8 and 9. 6 na. 8 and 9.
Right.
Daku.
Obliged.
How many of you all will see tomorrow?
Now I'm going to have to come tomorrow for Justice Rao because of the Calcutta.
The others
I have no desire to come. No desire whatsoever.
will disturb your lot.
Live streaming take off karo.